Adjournment request, if any, from item number 1 to 4. From item number 5 to 17, adjournment request.
In item number 4, I want to withdraw it with liberty to file it afresh because there are some formal defects.
Can I have your name, please? Can I have your name, please?
Yes, Sahad.
Mohammed A. Sahad,
Yes.
learned advocate for the appellate. This is a writ bill, no? Oh, you are only withdrawing the IA.
IA and what? IA and connected legal appeal.
You are withdrawing the IA.
No.
Got it.
Both
A-
IA and main in the legal appeal also. Because both.
Okay, okay. Anyway, Mohammed A. Shahad, learned advocate for the applicant, who seeks permission to withdraw the application seeking condonation or delay in order to enable him to file a fresh application with necessary details. The request is acceded to. The IA stands withdrawn with the liberty to the council as a person. All
From item number 5 to 17, adjournment request.
Lordship, item number 15, pass
Yeah.
over for the day, petitioner is not well. Is it okay?
you want a passover for the day?
Yes.
So no need of any order. Passover.
Hello.
From item number 19 to 25, adjournment request.
Like to mention item 22 and 23 of today's daily discussion. This matter, I prayed for some accommodation earlier to engage some senior. I appear for the HPCL lordship. I further pray for 2 weeks more time lordship in this.
As prayed for on behalf of the appellant, re-notify on give a date after 3 weeks.
Well, I'm praying for the respondent, my lord. So, can I pray for a date, my lord?
Yeah, you will get a date. You will get a
15-9.
Obliged, lordship.
15-9. Any other request?
Lordship, I pray for listing of an appeal next week, Lordship, on 26.
reason.
The reason, Lordship, there are some vacancies occurred, Lordship. Only because of the pendency of the appeal, Lordship, we have not been promoted. Or, Lordship.
Obliged, lordship.
Give your slip.
May-
Yes.
May I please, as a lord, so
Yeah.
my lord, I beg to mention for listing of a public interest litigation petition, my lord, on coming Wednesday, my lord,
Coming Wednesday is day after tomorrow.
day after tomorrow.
No, keep it next week. What is the matter?
My lord, the matter is regard a community in the Upper Assam districts, my lord, had been traced and they are being directed to immediately leave that place, my lord. And secondly, my lord, the policy of the state of Assam to provide the arms license to a particular section in the state, my lord, had been put
Next
into
week
check.
Wednesday.
Yeah.
My lord,
Next week
some
Wednesday.
urgency is there, those people are still being harassed, my
No,
lord.
no. That, I mean, urgency all right, but our calendar is full on that day. Next Wednesday. Give your slip.
My lord, can we on Friday, my lord, coming week? Obliged. my lord.
Wednesday. Yes.
My lord, I'm praying for listing this repetition, my lord. The other day, my lord, I made a mention, my lordship, that case, my lord, I have charged, my lord, the WPC 2617. There is, as regards the challenge to the amendment provision of 2025 regarding promotion to the post of headmaster. But my case is, but my lord, for, I am challenging the provision of Rule 12, where, my lord, the
Yes.
Monday, next Monday.
Yes, next Monday.
Monday. God bless, my lord.
May it please, Lordship. Lordship, I pray for an urgent unlisted motion at 2. This is a stake appeal from Kohima bench, Lordship. So it's regarding with the MBBS seat. The learned single judge, he has questioned, set aside the government policy of Nagaland, and he has even interfered into the extent of BDS, which is not the subject matter before the court. The petitioner is not eligible under the central pool seats meant for the stake of Nagaland. So, Lordship, there is an urgency in the matter, so I pray that the matter may be listed at 2 today, Your Lordship. Because there is no available bench in Kohima right now. It's a judgment dated 14/8/25,
Tomorrow. Tomorrow at 10:30.
tomorrow, Lordship, much obliged.
Have you served the other side?
Lordship, I have served to the Union of India also, and I have informed the petitioner,
Inform the council for the other side to be here tomorrow.
Lordship.
Madam, next Monday is a holiday. Madam.
Next Monday is a holiday. So that's Tuesday.
Yes, my lord.
Maybe on next Tuesday, I shall not be here, no? No, next Tuesday is not possible.
This Friday, my lord, if possible, my lord.
And then 26th.
My lord.
Lordship, sorry for indulgence, but Lordship, I've been informed that the petitioner, they have filed the contempt to be listed, unlisted motion.
That's all right.
today.
You, please address your appeal first.
Lordship,
We'll have the contempt listed before us. In
Lordship,
case we require to modify the order,
Lordship.
modify the judgment, we shall act accordingly.
Okay, much
Don't
obliged.
you worry, we'll have
Much-
the records.
Much obliged.
All right.
Daily list for orders, item 1.
May please, my lord.
Yes.
No, the service has not been returned, my lord. We may be allowed to take fresh steps, my lordships, coming.
The land council for the petitioner submits that in the event of the return of service not being intimated, he would like to serve afresh.
My lord.
Let that be done. For the aforesaid purpose, necessary requisites shall be filed by him in the registry within a period of 2 days. Whereafter notices shall be issued to response number 1, 3, and 4 by both modes, returnable on give a date after 3 weeks.
Obliged.
22nd September. Item 2.
Yes, question.
Lordship,
Yes,
Lordship, the issue has already been decided against us, Lordship, by a coordinate division bench. So delay may be condoned and my writ appeal may be.
yes, what do you have to say? Again, for the reasons stated in the application, the delay in preferring the appeal is condoned, the application stands allowed. List this matter. List the appeal, no? List so and so, accordingly, so and so date. Yes.
10-9. Item number 3.
In this case, there is a delay of 160 days. Notice may be issued in
Notice
the.
to go, no? Notice to the sole respondent on steps being taken by the state within the period of 2 days, 3 days,
3 days.
3 days, both modes returnable on so and so date, the date after 3 weeks.
22nd September.
Deeply obliged.
Item number 5.
First name,
May I please, the lordship, my lord, there is a delay.
State respondents, anybody appearing for state? You don't know the delay?
Well,
You need to, do you require to contest this?
In IMI,
68 days of delay.
no money.
Item number 5.
Financial.
We condone it.
Yes.
For the reasons stated in the, we have heard the lead counsel also and proposition. For the reasons stated in the application, the delay is condoned, the application stands allowed. The writ appeal shall be listed. Once.
8-9.
Obliged.
Item number 6.
May it please your lordship. Lordship, AD is still unserved in this case, lordship.
Which thing? All right, awaiting the service of notice and the appearance of the other side, the matter is adjourned to 2 weeks. I don't know why, again, I'll repeat the same thing. You should file an appeal.
I have faith in lordship. And item number 7 also, lordship, is this similar.
Review कहीं क्या था आपने? Was not review, the appeal.
Lordship.
All right, the journey.
Adjournment.
Yes.
In item 7 also, Lordship,
Yes.
similar order.
For admission, item 8.
Yes, who appears? We have recorded. We don't want to discuss it. We would not like to dismiss this unheard. You know, he has been dismissed from service. We'll give one more time. And that will be the last time. There nobody appears on behalf of the appellant. We notice from the order sheet that,
See, I'm sorry.
yes, yes,
I'm
yes,
sorry,
yes.
very
We were about to dismiss it, madam.
Lordship. Lordship, the punishment which has been imposed, that is disproportionate. On that count, we have challenged this, the order of the learned single judge, Lordship.
Yes,
Basically, Lordship, I'm taking your Lordship to page 6 of my
basics of your memo of appeal.
of the writ petition, Lordship.
Basics of the writ petition or memo of
Yes.
appeal?
Yes, appeal, memo of appeal, Lordship.
All right,
Yes, contention of the writ petitioner.
yes,
May I read the contention, Lordship?
yes,
The allegation of gross misconduct and dereliction of duty level against him is grossly untenable, as he had only obeyed the directives of the person whom he was attached as a PSO. Now,
can that be a ground?
Lordship, that petitioner, he was attached as a PSO to a deadly surrendered militant. That was his entrustment, and he was protecting him. On that fateful night, Lordship, when the incident occurred, he was asked by the protectee to get.
You handed over your arms to somebody else, not even to the surrendered militant, but to somebody else. We do not know who he was. And then you never reported the matter to the higher authorities.
That is,
And you also helped the person, the surrendered militant with whom you were attached as PSO, you helped him clean away the blood and all that. So I think you have completely derelicted your duty.
Lordship, to that, answering this, controverting this allegation, Lordship, absolutely, because while commencing the inquiry proceeding, Lordship, no eyewitness has ever been examined to substantiate that claim. That is only on the presumption of the inquiry committee held this allegation,
No
Lordship.
eyewitness with respect to the actual act of murder. But you have yourself admitted that you had left your firearms, you had gone.
That
to
is
the instruction of
true,
some-
Lordship. I was under compulsion to.
What compulsion can there be? I mean, if
I
there
was
was
under
any
threat.
compulsion, you were holding the arms with you, no?
And
Nobody would have compelled you. It was precisely for the safety of that militant, surrendered militant that you were there. You
Lordship,
should have known.
I was under threat, Lordship. Once I reached safely, then I have reported the whole incident, Lordship. It is not a fact that I have not.
That doesn't find mention in the departmental proceeding.
That is a
That has not been confirmed.
That is where, Lordship.
Anyway, you talk about the quantum of punishment now.
Now the punishment, Lordship, that it's a
If you
removal
call
of
it
service
disproportionate, you have to tell us why it is disproportionate.
in terms of that these are the grounds, Lordship, basically that and otherwise, Lordship, the dismissal, but because I have done nothing wrong with the department, Lordship. I have given my best to the department, and
See, PSOs are meant to protect people. You can't abet this murder. In fact, you would have been, that you have been acquitted by the criminal court is something different. But then you did not act as a PSO ought to have acted. We don't find the punishment imposed upon you to be disproportionate under any count. Sorry. Take that.
let there be, Lordship, withheld of increment and other sort of punishment instead of, because I'm the only person in the earning person and my
That is,
family is there.
You're invoking the element of mercy, which perhaps we do not have at the moment. In service jurisprudence, that cannot be done. You know the law with respect to, assessing whether sentence is disproportionate to the crime, to the offense, to the misdemeanor. That concept came very late, but then unless it shocks the judicial conscience, it should not be interfered with. You have read Ranjit Kumar's case. Correct? All right. Third, MST Som, learned advocate for the appellant, and MSRB Bora for the state. The appellant has questioned the judgment of the learned single judge dated so-and-so passed in WPC number 3435 of 2013, whereby the prayer made on behalf of the appellant for setting aside the punishment of removal from service was rejected. Stop. The prayer made on behalf of the appellant before the learned single judge for altering the sentence imposed as being disproportionate to the misdemeanor of the appellant also was refused. Stop. The records reveal that the appellant was posted as PSO to one Kukil Gogoi, a surrendered militant. On 13/9/2011, on the asking of one person associated with Kukil Gogoi, he left his firearms and went out to procure food for Kukul Gogoi and his associates. During this period, it appears that Kukul Gogoi used the firearm of the appellant in killing one of the members of his team, namely Sonal Banerjee, for which a criminal case also was lodged. The appellant was acquitted in the aforementioned case, but in the departmental proceeding, it was found that he had derelicted his duty and for no apparent good reason. He had walked out of the place from where he should have been on the pretext of bringing food for Kukil Gogoi and his associates. The contention of the appellant that such action was under compulsion and threat of his life by Kukul Gogoi was not accepted by the learned single judge, and rightly so, for the reason that the appellant never informed about the incident to his senior officer. Stop. It was only after he was arrested and put under suspension that the matter came to light. The further contention of the appellant that every aspect of the matter was narrated to the superior police officer was not found to be in consonance with the records available in the case. The learned single judge, after having found that the appellant was never prejudiced on any account as far as the departmental proceedings were concerned, refused to interfere with the decision of the disciplinary authority with respect to the quantum of punishment imposed upon the appellant, namely removal from service. We are of the view that unless the sentence imposed upon the appellant is shocking to the judicial conscience or is so harsh that it does not take into account the circumstances as also the delinquent himself, in his capacity as PSO, no interference is required to be made. The learned single judge, after having discussed all aspects of the matter, refused to interfere with the decision of the disciplinary authority. So we find no reason to interfere with the judgment of the learned single judge. We therefore dismiss this appeal in limine.
Deeply obliged. I'm deeply obliged.
Item number 9.
Yes. Yes, who appears?
Item 9.
Nobody appears on behalf of the appellant. Press this appeal. Re-notify on your date after 3 weeks.
17-9.
You want to let?
Item number 10.
May it please your lordship.
Yes.
Trial for respondent number 1, my lord.
All.
My lord, the matter relates to selection of assistant professor in a particular college.
Yes.
Now, my lord, if your lordship would kindly come to page number 31.
Yes.
There is a government notification, my lord,
Yes.
dated 24th of January 22, which lays down the criteria of selection it starts at page 29. And I'll have your lordship's kind attention to page 31. The heading is marking for academic records will be calculated as mentioned below. Please come to serial number 4. That so far as the mark of post-graduation is concerned, if somebody gets above 90%, then mark will be 30. If somebody gets
You're asking us to read
page 31,
page 31, column.
column number 4,
All right.
serial number 4.
Serial number 4 in that
Yes.
column. Yes.
This is post-graduation, my lord, how the mark will be evaluated.
Yes.
Now, if one secures 90% and above, then it comes, he gets 30.
Hmm.
If it is 80 to 90, then it is 27.
Yeah.
If somebody gets 65 to 80, then it is 22. Then from 55 to 65, it will be 17. So this was when the advertisement was issued, my lord, this particular notification was holding the field.
Yeah.
Then if your lordship would kindly come to page number 33A. Now there were 4 slabs. Now it has been brought down to 3 slabs. Now page 33A, more than 80%, 30 marks, 60 to 80, 27 marks, and 55 to 60, 24 marks. Now selection has not crystallized as yet. My lord, the writ petitioner moved the Honorable Learned Single Judge, saying that it's a case where after the game has been played, rules of the game have changed. Now, Learned Single Judge relies upon Tej Prakash Pathak's case.
Yes.
My lord, Learned Single Judge failed to notice Tej Prakash Pathak. Now, if your lordship would kindly come to the impugned judgment at para number page 48, my lord. Para 17 onwards, 2 pages only. Page 48, para 17. Though the qualification and eligibility criteria have not been changed by the respondent authorities in OM dated 22/10/24, that is the one at page 33A, yet it had changed the marking pattern. And if that was done only to accommodate some other candidates of college authority choice, the same cannot be permitted both in law and equity. Thus, in view of the terms and conditions as set out in the advertisement dated 2/7/24, that the selection procedure has to be governed by OM dated 24/1/22, the college authority, that is respondents number 4, 5, and 6, now cannot turn around and apply the changes so brought by OM dated 22/10/24 in the selection process.
Yes.
Therefore, in view of the submissions of the learned counsel for both the parties, and also in view of the given facts and circumstances on record, The real question to be determined herein is, in this petition is whether OM dated 22/10/24 is applicable in selection process of assistant professor in Mondia Anshalik College, Mondia or not. And as stated in the terms and conditions of the advertisement dated 2/7/24, the selection procedure will be governed by OM dated 24/1/22. OM dated 22/10/24 cannot be applied in the aforementioned advertisement.
No, that's right. You said that the single judge did not apply Tej Prakash.
Yes, yes. Now,
Yes.
if a lordship would kindly have 2025 2 SCC page 1.
Now, please take out Indian Medical Officers Association versus Union of India, 2023, SCC online, Supreme Court page 934. That's the latest law on point, whether it is
Yes.
midway. वो निकाल देना है, please. 2023 SCC online, SC 934. Yes.
Yes, my lord will kindly come to page paragraph 21.
23 session, let's see.
Analysis. To effectively analyze and adjudicate upon the questions referred.
Paragraph 21.
21, my lord. The heading is analysis. To effectively analyze and adjudicate upon the questions referred, we would divide our discussion into the following parts. Now, please come to D, my lord.
No, just a
Where-
minute, please read the whole of it.
Okay. When the recruitment process commences and comes to an end, basis of the doctrine, the rules of the game must not be changed during the course of the game or after the game is played. Whether decision in Manjusri is at variance with the earlier precedents on the subject. Whether the above doctrine applies with equal strictness qua method or procedure of selection as it does qua eligibility criteria. That means, my lord, my humble submission would be this, the referral court, my lord, recognize the subtle difference which exists between, my lord, eligibility criteria and method and procedure of selection. Though subtle, it did recognize. Now, my lord will kindly come to the findings on D at para number 54.
Yes.
Rule does not apply with equal strictness to steps for selection. As already noticed in section A, a recruitment process inter alia comprises of various steps like inviting application, scrutiny of application, rejection of defective application, or elimination of ineligible candidates, conducting examination, calling for interview or viva voce, and preparation of list of successful candidates for appointment. This is important. Subject to the rule against arbitrariness, how tests or viva voce are to be conducted, what questions are to be put, in what manner evaluation is to be done. I am on this, my lord. Whether a shortlisting exercise is needed are all matters of procedure, which in the absence of rules to the contrary may be devised by the competent authority. In fact, my lord, in Manjusri's case, if your lordship recollects, my lord, after the, my lord, selection was over, a 5-member committee was constituted by the Andhra Pradesh High Court, where the mark was scaled down from 125 to 100. So more or less it's the same situation, my lord. Earlier it was under 4 heads. Now it will be under 3 heads. So, my lord, I don't think, my lord, that principle or the doctrine that the game, once having been played, it cannot be changed midway. It applies basically to eligibility criteria. And, my lord, at that stage, nobody knew. Even today, my lord, the college authority has made the selection and forwarded the case to the director, and the director has not given its approval as yet. So to say, my lord, merely because the pattern of marking was changed, it can be construed to be a case of change of the rules of the game. With utmost respect, I'll submit may not be correct, my lord.
Let's see that OM,
Yes,
page 29.
yes. Now, eligibility criteria is under a different heading. There it has not been tinkered with. In partial modification of, and my lord, this is to everybody. It's not that this is a particular college. In partial modification of the government OM-Y dated 25/11/20, issued by the Higher Education Department, Government of Assam in the Higher Education Department is pleased to notify the following guidelines for selection of assistant professor, librarians in provincialized colleges and government model colleges of Assam. So first heading is eligibility criteria, good academic record as defined by the.
What was the reason for changing this, for bringing about this modification?
My lord, this has been done by the government, my lord, that we have got no control over it. It has been done by the,
You have got no control over it, that's true.
yes.
You are a candidate.
Perhaps, no, my lord, even the college authority has no control over it. It is the government. Second, a revision of calculation of marks of post-graduation. It is not a case that this has been applied only in case of the particular Mondia college. It is being applied across the board, my lord, everybody. I think, my lord, it will not be correct to say that there is no distinction between eligibility criteria and other aspects.
Eligibility has not been changed.
Yes.
Only the procedure.
Yes. Now, if your lordship can, and now, my lord, K. Manjushree judgment was affirmed in my lord Tej Prakash Pathak's case. Now, if your lordship should kindly have Manjushree's case for a moment. This is my lord 2008 3 SCC 512. My lord will first come to para number 2. Or lordship may kindly come to para 6. At page number 515. A committee of the 5 judges was constituted for interviewing the candidate, and interviews were held in March 2006. Thereafter, the marks obtained by 83 candidates in the written examination and interview were aggregated, and a consolidated merit list of 83 candidates was prepared in the order of merit on the basis of aggregate marks. It contained the registration number, name of the candidates, reservation category, marks secured in written examination out of 100 marks, and marks secured in interview out of 25 marks. This is how it was done. Then my lord will kindly come to para 8. The full court considered the resolution of the administrative committee dated 30/11/2004 and 4/4/2006 and record of the selection. The full court impliedly approved the resolution dated 30/11/24, but it did not agree with the selection list prepared by the interview committee and approved by the administrative committee by resolution dated 4/4/2006. Full court authorized Chief Justice to constitute a committee of judges for preparing a fresh list of candidates to be recommended for appointment of district and session judge. Accordingly, the Chief Justice appointed a 5 subcommittee of 2 judges on 7/4/2006. The said subcommittee was of the view that the candidates should be evaluated with reference to written mark of 75 and interview marks of 25. It was a case of moderation of marks. Now, please come to me, Lord, paragraph number 38. We at page number 528. We therefore find that the judgment of the division bench of the High Court has to be set aside with a direction to the AP High Court to redraw the merit list without applying any minimum marks for interview. The merit list will have to be prepared in regard to 83 candidates by adding the marks secured in the written examination and marks secured in the interview. Thereafter, a separate list have to be prepared for each reservation category, and then final selection of 10 candidates will have to be made. The scaling down of the written examination mark with reference to 75 instead of 100 is however proper. So this was doubted, my lord, and this was referred. And my lord, Tej Prakash case, Manjushree has been affirmed. My lord. I think my lord would like to examine this matter, my lord.
Just a minute.
And in কোন paragraph to appeal কৰিলে? ইউটিউবৰ আছে নেকি? Hmm? My lord, paragraph 65 in Tej Prakash, Manjushree has been declared to be a good law. Para 65. 65.3. Please have 65.3 and 4.
All that, like, meaning them, but for all. Then arbitrary or not, it will only be. Then, where it is already, why change? Let's see. Right. So we are stuck up at one particular point.
Yes, my lord.
Agree, it may not change the eligibility criterion,
Yes.
but then it was not something left open-ended, Mr. Chaudhary.
My lord, the problem
I mean,
is,
let me frame it
yes,
in a different way. We understand your argument that it is prospective, it is not arbitrary, it does not change the rule of the game, the eligibility is not changed, only the process of marking has been changed.
yes,
Whether this would be called a change in the rule of the game.
yes.
That also when evaluation has not been made up till now.
Mhm.
But then there is a legitimate expectation theory which can be invoked here
Yes.
because the process was delineated.
My lord, doctrine of legitimate
That is
expectation.
later. And that is in the context of Mr. Chaudhary with the understanding that a person
Will be fairly dealt with.
getting a particular marks in post-graduation will be marked this much.
Hmm.
So this expectation is almost a reality. I mean, this would have come if these rules were there. Because this is only with respect to postgraduate people, not with respect to others. So postgraduate and graduation marking, all this Manjushree and other cases that you have seen, there nothing was prescribed and things were changed.
No, my lord.
But here,
Here also there is no rules. This selection is not governed by any 309 proviso to 309 rules.
That's all right.
Hmm.
But then the advertisement referred to the OM.
Well, yes.
And therefore, for all practical purposes, we are not questioning any law or rule with respect to its enactment under 309 or the feasibility. When we talk of candidates, whether this would adversely affect the prospects, because they were thinking that even if they would get lesser marks for graduation, they'll get this marks with this percentage. So that for some,
No, my lord.
it will affect only few.
No, my lord, this was done before the interview. It's not that after interview it was done. Before the interview, it was done, my lord. It's not that after the interview it was done.
No, advertisement, all right, it says, it's right.
My lord,
It is-
that part is there. The violation of Article 14 can always be looked into. Now, question is it a case where it can be said, my lord, that to favor somebody it has been done?
That's a proposition which has been advanced. That has to be seen. Well, see, you can't expect, the courts cannot expect any affidavit or any statement in that account. But
Correct, correct.
suddenly changing this with no major change. So this can be understood in a different way, but why do you want to keep it to 3 slabs only when it was more elaborate in the earlier advertisement? That's what is striking me.
My lord, I think perhaps the objective, who gets 90%, my lord, in post-graduation level? 90% and above 30 marks.
So even then, if that.
So, my lord,
if
had
that
it
were
been a
the-
case, no, my lord, kindly see, scaling down was not to, eliminate the lower category. The person was seeking marks in, my lord, nobody will get 90. So whosoever gets 80 and above, you'll get 30%. And there's an, object to be achieved, my lord. It's not that there is no nexus. Because 90% post-graduation, I don't think, normally, unless mathematics and all this subject is different. Otherwise, my lord, 90% is something which normally one doesn't secure. Yes, if the tinkering would have been the bracket of 55 to 65, then at also we can say yes, because that is the percentage which normally people enjoy get.
Yes,
Well, only one thing, Milord. Paras 65.3 and 65.4 of Milord case Prakash, just small 2 paragraphs, Milord.
65.
Yes, 65.3 and 65.4.
Hmm.
Decision in K. Manjusri lays down good law and is not in conflict with the decision of Subhash Chandra Marwa. Subhash Chandra Marwa deals with the right to be appointed from select list, whereas Manjusri deals with right to be placed in the select list. The 2 cases therefore deal with altogether different situation. But this is important. A recruitment body subject to extend rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided procedure so adopted is transparent, non-discriminatory, non-arbitrary, has a rational nexus to the objects sought to be achieved.
This gets hit there at the rational nexus. Why?
So that's why.
Why this change?
No, Milord, the change is, earlier it was said, those who secure 90% and above, he will get 30%. Now 90% has been deleted. Now from 80 onwards evaluation.
Even without that, it would have made no change.
No change. Otherwise also.
Even without that, just a minute.
Yes.
Just let's see.
Hmm.
Why was it done? Let's see 31A.
To 31 first, Milord.
31 is 9.
31 and 33A.
30.
Hmm.
80% plus 27. So. Now more than 80 is 30 marks. It has been scaled down 60 to 80, 27. Now, why was this introduced? That is the logic which I would like to know. What was the rationale in bringing this?
No, Milord, to be honest, Milord, I
That
can,
you don't have any
that
control?
state will have to answer.
Yes, state. Who appears? He's not there. He's not lawyer person. Who appears?
College.
Standing Council Education, Higher Education.
Petition who? Copy, sir.
Yeah, she's come.
In fact, earlier
You're
it was
appearing-
17 marks.
What is it? Your name has not been shown. What is your name? Here. Look here. There is no representation on behalf of the state in its education department for the reason of the name of the council not being printed in the cause list. Let the name of the standing council education department be printed in the cause list of tomorrow. List this matter tomorrow for consideration.
Milord, will it
You
be-
would be addressing the court. You'll have to tell us, why did you change this? What was the purpose of making it all inclusive from 80% onwards till 90%? Did you have any idea? Did you go through the the candidate's marks before coming to this conclusion. And this is why. Why did you make this change? This change is not changing the eligibility criterion, but only the marks awardable. But how would it affect adversely any other person?
Exactly. And my lord, earlier 55 to 60, it was 17. Now it is 24.
And how are you affected adversely?
I got 90% and above.
Okay.
This is the reason, madam. 90% above, my other friend is saying that
So you don't get any less marks. You get marks similar to, I mean, as
Everyone.
much as any person with
My
80%
lord,
get.
let lordship get to know the object behind
My lord-
state's purpose, my lord, then lordship will take
my
action.
other kind is advertisement dated 2/7, 2/7, madam, 24.
No, but how are you put in a disadvantageous position?
No, my lord, because I have 90% because when they have changed, my lord.
Chalo.
When one day after advertisement, they. Oh.
My lord, will it be inconvenient day after tomorrow, my lord?
No, the process has been stayed, no?
No, in fact, there is an order against me. This is the first time it has come.
Okay, first time, day after,
Yes,
First time it is come, my
day after tomorrow.
day after.
There was condonation, it was condoned, my lord.
फोटो करते हैं। तो उसमें जो लिखा है उसको लिखना डे आफ्टर टुमारो। नहीं ये नहीं है। This citation may be wrong. This is TN medical officers. Citation may be wrong. TN medical officers in as a judgment by Justice Nasim. Day after tomorrow. ये सब judgments थे। Yes.
Yes, matter.
Item 11.
Yes.
The impugned judgment is at page 255.
Yes.
255. That paragraph 7, the relevant question.
Now, with effect from 1/8/2017, have you worked for 10 years?
No, I'm not. But all these appellants were appointed in the year 2010. So when this writ application was filed, they have completed 10 years. But on that day, they had not completed 10 years of it. Well, that is one aspect of this case. Second question is that whether
No, that's all right. The state government is agreed not to. Who appears for the state in this? So you tell us, forget about Upen Das judgment. Forget about the cutoff date.
yes.
Now you have put all people on muster roll, work charged and similarly placed. So they are contractual employees, they are also similarly placed. They have been working for 10 years now. If the cutoff date is not 1/8/2017, correct? So this was against some scheme which was developed and some scheme which was thought of. And it was very heartening for the judge in Upen Das to think about it, that you've taken care of giving them the minimum of the basic scale of a regular employee. Now,
Yes.
can that not be given to them? Notwithstanding the cutoff date provided in Upen Das and others for state of Assam and others. That's the question. The single judge has gone only on that. So that may not be actually relevant when they matter. If the prayer of the appellant was only that, then perhaps the single judge was correct. But if their prayer is that after having served for more than 10 years, they also would require a scheme to be formulated where they get parity of pay. Correct, Mr.
Yes,
Gupta, you
So
would
far
like to
our-
argue this? Would you like to argue this?
yes, no, but I can argue this too. Though the pair is not specifically so, but scale pay, minimum scale pay.
Have you examined the case of Jago?
No, I have done example. I brought the case that is
Jago by
Jagjit
Honorable
Singh.
Justice Jagjit Singh is quite old. Jago in 2024, the judgment delivered by Justice Vikram Nath. All situations, all possible situations, all kinds of employees, they have been taken into consideration, and a separate procedure has been delineated there.
Jago.
Jago. Take that. Right, Mr. A. Das Gupta, learned senior advocate for the appellant. And you are S. Datta.
My lord.
And Mr. S. Datta, standing counsel, PNRD. Standing counsel, PNRD. The appellants are aggrieved by the judgment of the learned single judge dated 20th of June 2025, passed in so-and-so, refusing to grant them parity of pay in accordance with the judgment in Upen Das and others was State of Assam and others give the citation. The appellants have worked as Gram Rojgar Sahayaks and computer assistants under the Manrega scheme. First off, they were appointed in the year 2010 after an advertisement was issued by the project director in 2009. By around May 2020, each one of the appellants have completed 10 years of continuous service. They approached the learned single judge with the sole grievance that despite their long service, they are not being given similar benefits as other contractual employees working in different government departments. Several representations preferred by them for that benefit has gone unheeded. A reference has been made in the memo of appeal that at one point of time, the state cabinet had taken a decision to grant similar benefits to contractual employees of Panchayat and Rural Development Departments. This information was gathered through newspaper reports, which ultimately was found to be incorrect. Nonetheless, the learned single judge, on perusing the judgment of Upen Das and others versus State of Assam and others, bracket Supra, found that the benefit would be given to any muster roll, work charged, or similarly placed employee who have worked for more than 10 years, even when it is not against any sanction post, to be counted from 1/8/2017. And therefore, since the appellants / writ petitioners were appointed by around April 2010, would not come under the beneficial scheme of the government for granting parity of pay. In Upen Das Supra, the court noted with approval the policy decision to not terminate the muster roll / work charged / similarly placed employees working for more than 10 years till their normal retirement, except on disciplinary ground or on grounds of criminal offenses, but enlist them in health and accidental death insurance, but enlist them in health and accidental and death insurance scheme, comma, to be prepared in consultation with the state cabinet. In Upendas Supra, the court had directed the state government to implement the measures without any delay, including payment of minimum wages, payment of minimum of pay scale to muster roll workers, work charge workers, and similarly placed employees working since last 10 years, bracket, not in any sanctioned post, comma, but with effect from 1/8/2017. This court would like to know whether any such scheme for such employees under the Manrega scheme who have worked for more than 10 years is being thought of. The state to respond by the next date. 3 weeks.
Seventy-nine. Item number 12.
May I please, my lord?
Yes.
Lord, here the order of the Central Administrative Tribunal has been challenged, my lord. Lord, there was a recovery ordered by my lord, the department on the ground of, my lord, there was a change in the policy, my lord. The third MACP benefits were wrongly granted to the, my lord, respondents, and thereafter, my lord, the recovery was initiated. So, my lord, the Central Administrative Tribunal has rejected, set aside the order of recovery, my lord, in terms of the judgment of the apex court, my lord, in Rafiq Mashik. But, my lord, one thing which has been, my lord, ignored is that, my lord, these employees have given an undertaking, my lord, when the revision of pay,
That is.
they have given,
Let notice the issue to the respondents on steps being taken by the appellant within a period of 2 weeks, 4 months, available on so and so date.
59.
73 CCS rule, the pension rules say that, no? It gives permission.
my lord, 73 is not applicable, my lord, because
Which
70.
rule is applicable?
my
There's
lord,
some
under-
pension rule which says that it has to be recovered, notwithstanding Rafiq Masi and all that. Anyway, we'll see.
My lord.
Item 13.
Yes, please, your lordship. Here the order of the Central Administrative Tribunal is, my lord, page 89. my lord. Only issue, my lord, the technical reject.
They are not Bandhua Mazdurs, no?
Only one thing, my lord, is,
Bandhua Mazdurs. You gave NOC to them.
my lord,
Did
this,
you or did you not?
yes, it
Then
was,
how
my lord,
can you take this plea now?
my lord, this Western Railway was given, my lord. Now subsequently on mutual transfer, my lord, to the NF Railway, my lord. And there is only this, so far OM is concerned, my lord, I only want to place my lord 111, my lord. Page 111, lordship, the paragraph 2, my lord, this, my lord. It was not
Page
done.
111.
Yes, my lord. A technical resignation, my lord, is concerned, my lord. 212, my lord. This benefit also admissible to the government servant who have applied before the joining of the central government, government service.
Just a minute, just a minute. As per Ministry of Finance, Read that 2.1.1.
Yes, my lord, this, my lord, 2. Roman 1, the government servant should intimate the details of such application immediately on their joining. This was, my lord, so far this point, my lord, was taken in the written statement also, my lord, and the ground also, my lord. And here, my lord, is he transferred, he joined in the year 2020, my lord. And my lord, the intimation was made on, my lord, this on 27/11/2024. After 4 years, this page 50. And my lord, his technical resignation is, my lord, it is, my lord, page 62, my lord. Resignation technical, it is on 2025 January, my lord. So this was, my lord, this out plea was there, my lord. So far, government servants should immediately details of such inform the intimate such application immediately after joining. So this was not complied, my lord. This is the guidelines, my lord, my lord. This must, my lord. This ground was taken, my lord, in written statement also, and then present, my lord. Otherwise, my lord, the others grounds, my lord, this shortage of employees, it was there, my lord. But what happened, my lord, it was mutually transferred from the Western Railway to NF Railway. And at that time, this was not disclosed, my lord. He applied and he appeared there, NOC was there. It was not that, but so far grade C is concerned, my lord, and this zone-wise recruitment is there, my lord. So we have no knowledge about this thing, my lord. And so far shortage of this employee, my lord, that at present, my lord, there is shortage. It is also true, my lord. And already I'm instruction is there. 58% already they apply for such technical resignation, my lord. These are the on the ground, my lord. When order was passed by the Central Administrative Tribunal, my lord, this OM was not considered. Although it's page 24 of the application, it was stated on the paragraph 411, the mandate of the benefit of technical resignation, it was there, but subsequent paragraph was it was not mentioned. We have in our written statement in page 82, paragraph 9, it was stated that they failed to follow the guidelines of Office Memorandum 17/8/2016. And so far, Western Railway was not party respondent in their original application also.
Technical rejection वाला paragraph which page? मैंने बाकी भी बताया technical resignation. I don't think. The respondent had approached the CAT for directing the appellant to grant technical resignation to him with all consequential benefits, as also for releasing the respondent from the post of junior engineer, North Lakhimpur, NF Railways forthwith with all consequential benefits. It appears from the record that the respondent had been working on the post of junior engineer before his joining in the railways. He had applied for the post of junior engineer civil against an advertisement issued by the government of Bihar. The respondent appears to have participated in the recruitment process of the government of Bihar and came out successful. It further appears that in the railways, after the appointment of the respondent in the Western Railways on 8/7/2020, he was allowed a mutual transfer in the year 2024. However, the call for however, the respondent was called for participating in the process of selection in with the government of Bihar sometimes in the year 2022. At that time, the railway administration had granted him a no objection certificate for participating in the selection process. The result of the selection process came out in the year 2025, and the respondent was issued an appointment letter as a junior engineer civil under the government of Bihar. At that time, the respondent considered the necessity of resigning, bracket technical resignation, for which necessary application was forwarded to the concerned authority. However, when no decision was being taken by the railway administration, the respondent was forced to appear before forced to approach the CAT for the needful. The bench of CAT, finding that the respondent was given no objection certificate by the railway for appearing in the selection process for junior engineer civil with the government of Bihar, directed the railway administration to accept his technical resignation without any delay. It was also clarified that the respondent would have no lien over the current post that he was holding in the railways. After he would join the service at Bihar. The railway administration has challenged the aforementioned decision of the CAT in the present writ petition. On the grounds that the respondent was granted mutual transfer, and at that time no information was provided for appearing in any selection process outside railways. The second contention on behalf of the railways is that for the paucity of officers in the NF railways, it was not possible for the railway administration to release the respondent from his current assignment. Both the aforementioned contentions do not appear to be correct. Both the aforementioned contentions do not appear to be tenable. There is no denial of the fact that the railway administration had granted no objection certificate to the respondent for appearing in the selection process of the government of Bihar, and that paucity of hands in a particular administration would be no ground to forestall the career prospects of an employee who would like to have an appointment with a different organization. There is if no rules have been violated and there is no condition of the respondent claiming any lien over the post in the railways, even after he assumes the office of the post on which he has been appointed in a different organization, there is no reason why the same should not be allowed to. We therefore find that the CAT was absolutely justified in directing for accepting the technical resignation of the respondent. Finding no merit in this writ petition, we dismiss it.
Deeply agree.
Item 14,
May I please, your lordship?
Yes.
Lordship, this is a public interest litigation, my lord, filed by the residents of Vita and Moiragora.
For state dumping site in the middle of the village. Who appears for the state?
Mr. Moga.
Pollution control board comes next. Who appears for state of Assam? District Commissioner Barpeta, Municipal Board, Pollution Control Board. All of you would be required to be here. Who can justify a dumping site in the middle of the village, near the school, near a hospital?
Yes, my lord.
You are violating Environment Protection Act, Air Control and Pollution Act, Water Preservation and Control of Pollution Act, Solid Waste Management Rules. You have to do something to remove that. I need a response from you. Just don't keep quiet, no?
This has come for the first time.
This may have come for the first time, but I need your,
I-
at least you note that yes, it is required. We'll be filing an affidavit
Yes, my lord,
after
we'll-
necessary,
Lordship.
after necessary
Lordship.
decision in that
Lord,
regard.
I'll take instruction and we'll file the affidavit in the matter. For 1, 2, and 3, I'm appearing, Lord.
You are appearing for whom?
1, 2, and 3, Lord.
1, 2, and 3 are the state.
Yes, State Municipal Directorate of Municipal Administration, District.
And who appears for Assam Pollution Control Board?
I'm appealing for
What have you been doing?
that.
Sitting in the office won't help, no? Just sitting in the office won't help.
Ultimately,
Was the matter reported to you? Earlier at any point of time?
No.
No?
No.
Are you sure?
Yes.
You maintain such correspondences?
No, I've come because we have to.
You have
file
no
a report.
instructions in the matter, why do you say no?
We
The
have to.
case of the petitioner is that they have been representing to you. In fact, you should have taken lead in this matter.
So on the next occasion, we'll come up with the updates as regard how consent has been.
So that should
allowed.
come from you straight away, not on my plodding.
Yes.
Like this public interest litigation has been filed by the residents of village Itar Vita in the district of Barapeta, Assam. a open dumping site, an open dumping site has been created by the Howley Municipality Board, the Howley Municipal Board. Stop. Even before the site was created, the people of the municipality made very strong protest and gave written representations to the authorities, but to no avail. Ultimately, the site so identified by the respondents is being used to openly dump all kinds of waste, domestic and commercial, without any treatment or proper waste management measures. Very near the site, a school, a hospital, a namghar, and a temple are located. This is creating environmental and health hazard and is also causing clear public nuisance. The Learned Counsel for response number 1 to 4 seek some time to take instructions in the matter and get back to the court, this court with the correct with the remedial steps. Re-notify on so and so date.
My lord, in the interim,
4 weeks.
in the interim, my lord, the Howley Municipal Board will be restrained from dumping the.
Let's see what is.
Without instructions.
Let's see that.
Then on the retardable date, my interim matter will be considered, my lord.
After 3 weeks. 3 weeks, 4 weeks.
Obliged, my lord.
24/9. Item 16.
Maybe the lordship.
Yes.
Lordship, this matter lordship relates to non-payment of contractual bill lordship, part payment lordship. Yeah, lordship.
Yes, what do you have to say? Any dispute with respect to the raising of the bills?
Yes, because ultimately it has been rightfully decided by the single judge. The amount which was initially raised, that has been.
What has single judge
disbursed.
decided? Let's see.
So, yes. If your lordship goes
Just a
to.
minute.
Judgment.
Now, what is this report of the subdivision officer Salmara? What is this report of Salmara? Report submitted as the civil law.
We have.
Rupees
Yeah.
62 lakhs 97,000 was deducted from whose bill? No, what is this? I don't understand.
What the lordship may only go to the lordship, what is the
No,
order
please-
decided?
Please come to paragraph 3 of the impugned judgment.
Yes, lordship.
Read that, any one of you.
Yes.
I don't understand what.
The respondent have filed the affidavit in opposition, and in the affidavit in opposition dated 6/1/2025, filed by the respondent number 8, namely the Assistant Commissioner Bongaigaon, there is a specific averment in paragraph 4 of the affidavit that an amount of 6 crores 98 lakhs 62,000 was received from the demand raised by the Revenue and Disaster Management Department. The Government of Assam, and upon receipt of the said amount, a banker check of the full amount of the said amount was issued in favor of the then Executive Engineer, Dhubri Water Resource Division, to facilitate payment to all contractors. As per the amendment made in the said affidavit in opposition, the question of balance payment does not arise. The entire amount payable to the petitioner has been forwarded to the Executive Engineer, Dhubri Water Resource Division via the banker check, and the Dhubri Water Resource Division has released all the payment to the contractors, including the debt petitions.
No ground, no?
Lordship, prior to that, Lordship, only one fact.
Tell us one thing, whether he has raised the bill correctly or not. Whether he has raised the bill for the work which has been completed in accordance with the scheme. The rate which was allowed to him.
Yeah. So
Now,
for
that the project was to be concluded, it had to be, I mean, all payments had to be made within that disbursal is none of the concern of the appellant here. None of the concern of the appellant here. We are also not concerned with that.
yes,
Now, if he has raised a bill and if the bill is in order, it must be paid. You must generate that fund, you must earmark another fund or you take fund from somewhere, but you can't leave a person unpaid if he has done his work.
so for that matter, again, if we just go back to the next paragraph, it is total amount of
Paragraph 3. does not
total
convince
amount of
us.
7 crores 61 lakhs, and out of these
We are
six,
understanding
yes.
this.
So
Now, whatever may be the project.
there has been
whatever-
an inquiry.
Just a minute, please hear the.
Yes, Lordship, I'm so sorry.
Whatever money has been released on that head, that's one thing.
Yes,
But then if his bills are correct, it is in accordance with the rate and the work is complete in all respects, can you stop payment? Can you take this plea? Paragraph 3 means nothing to us. Take instructions, tell us.
yes,
Otherwise, we'll issue direction for making good the payment.
because
We are not in agreement with the judgment of the learned single judge.
Water is, they say, Lordship, yes, this bill is, Lordship,
Ask your executive engineer to file an affidavit.
yes, Lordship, they admitted this fact, Lordship, before filing affidavit, Lordship, water is.
I am appealing for the water resource department. Lordship, we have execution of the work is done by the water resource department. Then, Lordship, we have verified and submit completion certificate to the deputy commissioner. Thereafter, deputy commissioner.
These are all irrelevant facts.
Amount difference.
In the process of completion of the project, you commissioned the services of the appellant.
Yes.
Right? You must have given him the rate schedule.
Yes.
He has completed the work is to your satisfaction and the bill which he has raised is according to the schedule. So how does it concerns us or how does it concern him if some amount has been released and it does not cover his bills? Now you have to make arrangement, no?
Inquiry photo is ready.
Well, where is your affidavit? Let's see. You say that this is not a correct bill.
We have filed our affidavit.
Obviously, you people are not understanding what the court is trying to tell you. Look here, the appellant, as a contractor, was entrusted for construction of several works under the Water Resources Department. Dhubri Water Resource Division, Dhubri, on the river bank of Boraguri, Lengti Singa embankment at Dumerguri of the AIE River for the year 2009-2010. The appellant appears to have completed his work, partially paid for it as well. However, the balance payment of rupees 15 lakhs 88,499 have not yet been paid to him. The appellant therefore approached the learned single judge for a direction to the state, to the respondents, to make such payment along with an interest at the rate of 18%, as the payment appears to have been withheld without any lawful reason. The learned single judge, however, relying on the affidavit filed by respondent number 8. Indicating that an amount of rupees 6,98,000, 6,98,62,000 was received from the demand raised from was received from the Revenue and Disaster Management Department, which was released in favor of the then executive engineer, Dhubri Water Resources Division, to facilitate payment to all contractors. Comma, found that the claim of the appellant was not tenable. We fail to understand as to how the release of the fund would extinguish the claim of the appellant unless it is shown that the bills have not been correctly raised, or that the bills have not been correctly raised, or the work has not been done satisfactorily. So, release of fund in favor of the executive engineer would not necessarily make it, would not necessarily the affidavit of the executive engineer, water resource.
Page 61, Lordship.
The chief engineer of water resources department has gone on record saying that the work allotted to the appellant has been satisfactorily completed, and that the bills raised by him are not incorrect or false. In that view of the matter, we are not in agreement with the opinion of the learned single judge that the balance payment of the appellant as raised by him ought not to be defrayed by the estate. However, before directing the respondents to make good the payment, we would like to have a clear affidavit in this regard by the executive engineer of the water resources department by the next date. Re-notify on so and so.
15:9.
May I just interrupt? If it can be instead of the executive engineer, chief engineer, because in most of the cases,
Chief engineer has filed.
there is a standing order of this honorable court also in several cases.
That's right, Mr. Saikia. What has happened here is this. Now the learned single judge has taken note of the fact that 6 crores and odd was the amount which was raised, and entire amount was given by banker's check to the executive engineer. Now that does not cover the expenses which he has incurred. If you can say that, you can deny him payment if you say that bills are over, the bills are wrong or exaggerated, or work is not to your satisfaction. But without saying that, your chief engineer certifying that work is good, why the payment would not be made? That's the whole question. So therefore,
In
the
that
affidavit
the
must
case
come
it's
from the
okay.
executive engineer.
Otherwise, Lordship, only thing is that in some cases, executive engineer always gives. Malay Justice Chaudhary will know that. In our state, in some.
So
No,
that-
it's okay.
Let the-
Absolutely
let
fine,
the-
Lordship.
Let the executive engineer file an affidavit.
Yes, yes.
That
Or-
his bills are false, exaggerated, or it is not required to be paid.
No.
Then grounds, that's the only reason.
No.
But this cannot be the reason that we have released the fund, therefore this cannot be paid. This cannot be the reason. Yes. You can always withhold payment if the work is not to the satisfaction. If the rate, he has not raised his bill according to the rate schedule, then we will dismiss his petition straight away.
My only concern is that I'm not singling out this case. Generally, Lordship, lot of this kind of certificates come from the executive engineer, which at the later stage are found to be
incorrect. Here the situation.
It is the reverse. It is the
Chief
reverse.
engineer says it.
Lordship.
So therefore, the executive engineer will say.
Deeply obliged.
अच्छा एक बात We'll come back again at 2.
Lordship.
Mr. Saikia, there is a matter which you had said that.
Yes, that is the next item, Lordship.
Okay, next item. So
Next,
after.
at 2 o'clock. Affidavit we have filed on, both the sides have filed it.
All right. Have they brought anything on record?
They have brought record except the title, they have brought all other things like ration card, electricity connection, all these things.
For admission, item 17 and 18.
Yeah, plus court order.
Appeal to Ulua, appeal to Ulua. Appeal to Ulua. Atalat Rahman.
Yes.
May I please, your lordship?
Yes.
My lord, pursuant to the last order of my lordship's, my lord, the state has filed an affidavit, my lord.
Yes.
And if my lordship may be pleased to take up the affidavit, my lord, they have made a statement that the area wherein we are residing, my lord, in paragraph 4, my lord, at page 682.
One second.
My lord. Constitution. Eighteen 91.
Yes.
Now, my lord, I beg to draw my lordship's
Which
attention.
paragraph were you pointing out?
My lord, I am reading the, my lord, paragraph 4 at page 682, my lord.
Yes.
Says, my lord, that the deponent state,
That I've read.
my lord,
That I've
that
read.
they have said that, my lord, this is a notified by 19th of April, 1888, covering, my lord, so and so hectare of land. Now, my lord, our case is that whether, my lord, the area before our, my lord, alleging that we are encroaching this particular plot of reserved forest, my lord, there has been no demarcation as had been done. Now, my lord, they have annexed a map. If my lord may be pleased to take up annexure A at page 686, my lord.
Yes.
Now, my lord, this is a map, and from this map, my lord, I do not have that expertise, my lord, to earmark the particular area wherein we are residing or which is the boundary they have earmarked, my lord. So this is a map which I am very constrained to say, my lord, from this map, it is not very clear that we are within this map or outside the map area.
Mr. Boyan, denial like this is not acceptable.
My lord. My lord,
This denial is not acceptable. You have to come out with an affidavit that this statement is incorrect, that it has not been demarcated.
my lord,
It's a revenue land.
my lord.
If you have not done that, we would be the last persons to make you stay there. All others have left.
My lord, what my respectful.
This
My-
is no, to tell you a fact, this is no eviction. This is only preservation of forests.
My lord,
Otherwise, we would have taken all care to give you all the benefits, all the procedural, protection that a citizen is required to have. You could not have entered in the first instance. And you can't say that why was I allowed to enter? That is because of the operation under stealth. That is, you have not been able to make out any case for you.
No, my lord, may I try to satisfy my lord on this subject, my lord, if my lord allows me some time, my lord.
No, then perhaps we
No,
will
no,
hear you,
time,
but you'll be required to vacate it.
no, no, my lord,
Subject to
no, my lord,
further-
I am not asking for another day, today itself.
Yes,
Today
yes, we'll
itself.
hear you.
My lord, the issue as regards that the demarcation and my lord has said that there is no procedure is required. Now, if my lord may be pleased to take up my affidavit, my lord. It is a bulky and a voluminous one, my lord, what we have done. My lord, we have annexed a list as well as the certain documents by which, my lord, we have been allowed to construct our houses, residing therein, my lord, since long.
Which was that paragraph?
My lord. Documents left. My lord may be pleased to take up page number 430, my lord.
Yes.
That the deponent further state that number 2 Nagariville village fall under the Merapani Gaon Panchayat and the said villages was brought under the Pradhan Mantri Gram Awas Yojana and many people, including the appellants, got houses under the said scheme. Although the allotment orders does not disclose as the areas, but the list published in the website indicated the area. The appellant in the writ petition only annexed some of allotment orders, but herein now the appellant begged to annex the list. The list published in the website indicated the allotment number and area, which indicated the name of the village as number 2 Nagariville. The appellant prayed for verification of the list by the authority if need so. That apart, in the present context, it is pertinent to mention here that before allotting home under the said scheme, the government verifies the land and makes the geotech photography of the land and entered the same in map, which is done in case of the appellant, and after doing all this, the homes are allotted which clearly indicate the lands are not forest land. Annexure 4 is the my lord list which we have annexed before my lordships, my lord, in this affidavit, which my lordship may be pleased to find. Page number, my lord, 449, annexure 4, my lord. Lord, we have typed the relevant portion, my lord, for the convenience of my lordships, my lord, is at page 449, my lord. So, my lord, these are the area.
No, that you have been allotted a place in village number 2,
My lord, my lord,
near bill of Merapani.
my lord.
So this village, if it falls in Merapani Panchayat, Golaghat LAC, I think situation is different. But
That,
inside the forest area, I don't think.
my lord, that if, my lord, if within the forest area, from my very limited knowledge, my lord, what I respectfully beg to submit, my lord. My lordship is well aware as regards the T and Godavaram's case, my lord. If my lord allows me, my lord,
Godavarman has been repeated a number of times.
no, repeated number of time, and here is also, my lord, here is also relevant, my lord, what I respectfully and humbly beg to submit, my lord, is that there is a direction that the irrespective of the notification of a particular area, my lord, as a forest land, there is a direction, if my lord may be pleased to kindly, my lord, just for a moment, my lord, we are
Landless poor people, my lord, only your lordship is, my lordship is the last resort, my lord, for our survival, my lord. We have small children, homeless people are residing in the streets here and there, my lord. No scheme for their rehabilitation, my lord. The situation is very pathetic, my lord. In the ground level, my lord. If my lord may be pleased to take up, Dukhan diya na copy. Oh. I straight away like to draw my lordship's attention, my lord, to paragraph, my lord, 4, my lord, 5. Paragraph 4 and 5 is, my lord, relevant, my lord. Copy as an stars. Got it, got it.
There is a, there is a fallacy in this reference.
My lord.
And, these are meant for, these things were meant for recognizing, identifying the forest areas.
Exactly, my lord.
These are not reserved forests, and that was also for the purposes of, setting up those
No, my lord.
sawmills.
But my lord, this is a general order issued, my lord. We further direct as under.
See, look at
My lord.
this. These identification of forests were for the purposes of, the source from where these sawmills or veneer and plywood.
Collection
should
of
have
woods and timbers, my
been
lord.
put in timber.
My lord,
Here,
my lord.
it is absolutely prohibited, nothing. You can't enter that forest. In fact, the government would be well advised to charge the government officers in charge of protecting that forest.
That is correct, my lord.
And their
That is correct.
pollution has caused all this. Because if you are, that is a separate aspect altogether, but why should you be there?
No,
That
my
you're
lord.
landless, that you're poor, we have all compassion for you.
My lord.
But equally important would be the balance, the preservation of ecological.
Balance, my lord.
We can't do
My
it.
lord.
This is perhaps the only place where, rains are attracted on time. It's because of the greenery. You can't possibly do that. Once you do it, you sort of lead the way, others come. And
Lord.
that apart, you have started activities there. You are growing.
My lord,
peatlands,
those activities, my lord.
fisheries.
My lord, those activities, even the fishery department, my lord, has given the permission to dig the fisheries and do the business. My lord, that is,
Only one thing that one.
now, my lord, another limb of my lord. But my lord, TN Godabai for.
This is statement is not, making us believe that you are being evicted from, you're not being evicted from forest land.
Lord, that
This
if
doesn't
if a fresh
You
demarcation.
said that this does not fall under the reserved forest area.
No, my lord, I have just read over, my lord, the paragraph, my lord. I have just read over, my lord. Paragraph that connecting with the, my lord.
Clarify.
My lord, my lord. We have said, my lord, in paragraph, my lord, in para 7, specifically, my lord, they said scheme, which is done in case of the and after so and so, which clearly indicate the lands are not forest land, my lord.
Mr. Saike, where are these villages? The names that he has taken, Nagarbil village number 2.
Maybe they themselves have given some name. That is not the issue, Lordship. The issue is that these are all within. I have a clear photographs also. Where they are all residing.
No, that's all right. All these villages, are they part of the reserve forest area?
These villages, I do not know, Lordship, because I have to verify. There is no dispute about which is revenue village and which is a forest.
Right, that's
That is,
right. So if they say,
they are staying there in large numbers, so they may given some a name of their own.
where is that document?
My lord, these are the.
Show me that document which led you to stay in that village or the
construct the
house
houses, my lord.
out of Prime Minister's compound.
Yes, my lord, we have annexed the, my lord. This allotment orders, my lord, maybe please.
We'll
take
see
my
one such allotment order. Where is that?
Page number 360, my lord. My lord, may I kindly turn to page 364, my lord. My lord, to make the affidavit less bulky, my lord, we could not annex, but we have all those, my lord.
364.
Page number 364 of my affidavit, my lord.
Your affidavit.
No, no, my lord, it is in the writ appeal, my lord. Sorry, my lord, it is in the writ appeal, my lord. So, I'm sorry, my lord, it is in the writ appeal. My lord.
Yes, ma'am.
So, appeal to some. It is the নাই নেকি? Oh.
This makes it very clear.
My lord,
This is development block Gomari Guri.
my lord.
Should be a reserve forest. Otherwise, the
Develop-
Golagat.
My lord, the development block would have no role to play there, my lord, if it is within the, my lord, reserve forest, my lord.
Therefore,
This is,
this address means nothing to us. We are interested. Let you not be evicted from these houses. No
Exactly,
problem.
exactly, my
But
lord.
this is not the.
Subject to this.
This house, if you are residing in this house, well and good, the state will have no problem.
Exactly.
Question is that if it falls in the forest area, then this is forged. This is fabricated. This cannot be given effect.
No, it is not a, my lord, forced document, my lord. This is a document issued by the authority having, my lord, may kindly turn to the vernacular, my lord. It's in the next page.
Mr. Secretary, you just deny these allegations.
Number two, this was issued in the month of March this year,
Can't be, no?
No, my lord.
3-4 months ago, whether the house
you
is
say-
constructed or not,
You say that you have been.
whether the money has been disbursed to them or not.
No, my lord.
What are these allotment certificates? Are these genuine ones or forged fabricated ones?
It may have, because there must be some manipulation at some level. No government officer will allow a person to construct a house in reserve forest.
You lose his job.
He will lose his job. And if in this case also, Lordship, be pleased to pass an order, an observation that who the forest officers who are responsible for allowing the people to enter and stay
They
there.
should be proceeded against.
Absolutely, Lordship. And there should be a regular submission of report to the registry also from our side.
My lord, what my respectful submission before my lord is that, my lord, there is no manipulation, there is nothing as such. Fund has also been released. Out of that fund, my lord, we have constructed our land.
Has been released. We
Mile.
to the extent of saying this. Reserve forest area, we cannot permit. Law does not allow us and our conscience doesn't allow us.
No, my lord, as a conscious citizen, my lord, it is also my duty to protect the forest area also, my
Exactly.
lord. But otherwise also, my lord, the value.
Go back to your native place in Nagaon or.
Nagaon, Morigaon, Kachar, Hailakandi, Borpeta.
My lord, another aspect of my argument, my lord, is there. My lord, my coming to before my lord as a division bench as a letter patent appeal against the single judge's order, my lord. Wherein, my lord, we have said that there should be a due procedure of law before, my lord, vacating, demolishing the structures, my
You
lord.
have answered, no?
No, my lord, they are saying that there is no procedure is required for the person evicting this type of forest land. my lord.
Reason is
My
that,
lord.
the natural presumption is that nobody will enter that forest. It has to remain as pristine could ever be.
No.
Therefore, no need of following such procedure. That's the difficulty.
Now, my
Now,
lord, they.
do we have a specific procedure that the lawyers would not come this side to argue their cases, or they will remain there?
No, we have.
These are understood.
My lord.
These are understood. So therefore, a reserve forest, once it is notified, it's a reserve forest, no activity, nothing of the kind.
But my lord, for the two different reserve forest area, they have adopted two different procedure, my lord. Just for a
That's
moment.
different argument again.
No, not different, my lord, because it is connecting, because there is a discrimination. my lord.
Kind of procedure has been adopted.
Yes, under the 1920, my lord, the Forest Act, if my lord may be pleased to take up my affidavit, my lord. If for the Gwalpara Reserve Forest, my lord, what they have done, if my lord may be pleased to take up my lord, affidavit at page 675, my lord, the additional affidavit annexure 10, miss. This is a notice, my lord, issued under the Forest Conservation Act of 1980 of the Honorable Supreme Court and High Court's order. May I read, my lord?
So ultimately, the single judge gave you 7 days, we gave you 15 days.
No, my lord.
So
but-
that makes it 21 days.
But my lord, that the procedure which has been adopted
Same
by
procedure.
the Forest Department, my lord, has not been adopted in our case, my lord.
The answer is there in the notice itself, Lordship. If I am allowed to point out,
Yes.
this is in respect of right of any proposed reserve forest. It is not a reserve forest till now.
My lord, it is.
It is highlighted.
My lord may be pleased to find that therefore you are hereby called upon submit documentary evidences if any
You
within.
haven't been able to make out any case.
My lord,
Anything else that you want to say? I mean, we have all sympathies for you.
my lord.
But we have our understanding that you would not be rendered homeless, just that you will have to come out of that reserve forest area.
Then, my lord, they can, my lord, make a policy for our at least temporary arrangement.
Why?
Because, my lord, we are the citizen
many-
and my lord, the various.
How many of you would be there? Not only 10,
No, my lord, we are
lakhs
here.
and lakhs. And you're not landless. Where have you said you're landless? Where have you said that you're
No.
flood affected?
We are landless, my lord. We have stayed in our petitions also, my lord. My lord, they can verify, my lord. If land in our name, nowadays, it is very easy to find out from the website also, my lord. We are absolutely landless, poor people, my lord, residing therein since long 30, 40 years, my lord.
How can that be possible? One of these samples you've given is 4 months old.
No, my lord, the documents, my lord, which we have relied, my lord, admittedly, we do not have any title, my lord, in our favor. Now, my lord, as my respected Advocate General has said, my lord, just few minutes back, that there cannot be any title. We cannot produce any title. My lord, in a forest land, we automatically cannot have the title. There, my lordship is well aware, under the Forest Regulation Act of 2006, the Forest Dwellers and the Other Forest Dwellers Act, my lord, when they are residing in a particular forest area before 2005, there is a procedure, my lord, that the title can be offered to those persons also, my lord. My lord, very unfortunately, my lord, what I am, my lord, back to submit, my lord, this eviction process is also a selective, my lord. Selective and targeted to a particular community, my lord. The rest of the community has not been disturbed, my lord. My neighbors, my lord, who belong to a different community, they have not been disturbed. Their houses are still intact. If a survey is made, if the government is so conscious, my lord, about the reservation of the forest, then it should be cleared, my lord. A to Z clearance of the area should be there, my lord. That is in another respect, my lord. Article 15 has been blatantly violated, my lord. This policy is, my lord, basing on the gender, caste, creed, my lord. My lord, in paragraph 10 of, my lord, of our affidavit, my lord, at page 432, we have specifically pleaded, my lord, before my lordships, my lord, regarding this discriminatory eviction drive, my lord.
Page?
Page 432, paragraph 10, my lord. ফোন মাৰি থাকে ভতিজাটো আইচিইউত আছে কিবা হ'ব পাৰে যে আপুনি হেৰি কৰক
Mr. Bhuyan,
My lord,
your statements are contradictory. Now come to paragraph 11.
my lord.
Why do we believe such affidavit?
That, no, my lord, the affidavit
Now,
based,
one you have talked about selective eviction,
my lord.
that we do not have any material to sort of believe this statement, and then read paragraph 11 of your
That the
affidavit.
deponent, that in the present context of the case, the deponent further respectfully begs to state that the appellants or their ancestor many years back, out of the bona fide belief that the lands are not forest land, purchased the possessory rights of the said lands after perusal of the
Can
relevant.
does this go with your earlier statement that you were allotted land under the government scheme?
No, no, my lord, my lord, what is the stand?
He says possessory rights they have purchased. So therefore, this is contradictory, Mr. Boyan.
No, my lord, the issue is that, my lord, whether we have the title in our, my lord, I have to submit fairly before my lordship, my lord,
For title.
that we do not have the title, my lord.
Can you have the title in a
No,
forest land?
no, my lord, we cannot have, but there is a provision under the law of the 2006 Act that the title can be conferred after verification that whether under the 2006 Act we are entitled or not, my lord. If
Nothing.
not,
In
my
the
lord, they
in the
can
reserve
reject.
forest, nothing.
But my lord, this discriminatory, if my lord call for a report, my lord,
Now, what
it will,
discriminatory?
is-
How do you prove it?
my lord, we can prove it because, my lord, now, my lord, those persons who are residing therein, we are not saying, my lord, that they should also be evicted or they should also be made homeless.
You're saying is not saving them. We are directing the state to remove everybody who is in the forest area. They can't pick and choose. That
But-
they have chosen you first, that's a different thing.
But my lord, by following the due procedure of law, at least the principle of natural justice, my lord.
What due process do you want?
My lord, the due process mean at least the notice which has been
So
issued
7 days notice, we will henceforth ask them to give you 15 days notice. And in this case, you have got 21 days notice.
from today, my lord. My lord.
You have already got 21
No, no,
days
that
notice.
is, that is the mercy of my lordship, my
No,
lord. We
no,
are,
it's,
my lord.
we are not kings or emperors here. No mercy.
My
You have a right to argue.
My lord.
We are permitting you to argue.
My lord.
Now, question is this, that henceforth, your apprehension that you're being selectively, you're being cherry picked,
Exactly, my lord.
that cannot go because the state will be under an obligation and a direction of this court to remove all encroachment. They would not be called the aggressors in any sense of the term. They are under an obligation to do that.
No, my lord, those people are also poor and homeless people, my lord.
And so therefore, if you make a distinction, we'll ask them specifically, we'll say them that if they are there, please ensure that they are also evicted.
No, my lord, we should be also allowed to remain there, my lord. My lord, my lord, if there is no procedure is there, my lord.
This is, they have done that. They have done that. Mr. Advocate General, do one thing. This we are disposing of. But next, if you find, if there is any person who claims that he is residing there, give him a notice of 21 days. Just listen to him, find his rights. Tell them in writing that no, this is a forest land, all this is useless. Even if there is a house allotted inside the reserve forest, we will have it demolished. We will take action against the officer.
Instead of 21, could it be 14 days, Lord?
14, we give you 11 days, but do that.
Yes, Lord.
Here we are.
Because the law is silent because nobody contemplated this.
That's right. Mr. Saikia, you would agree.
Yes, that's why Lordship, if Lordship passes that order, we'll uniformly follow it everywhere. No difficulty. We have an analogy, Lordship. We wanted to remove some of the vice chancellors of universities. And in the university regulations, there is no procedure laid down to remove a vice chancellor or draw up any departmental proceeding. The reason being very simple law. Now, new laws are having that because lot of vice chancellors, nobody thought at one point of time that the vice chancellor will commit some kind of misappropriation of funds. So we remove two by taking general clauses acts for help.
Give them a notice.
So here, Lordship, if Lordship directs them, that will follow.
No, here we have done. Here you are satisfied that we have given you time. We are the same thing you'd have.
The very first day I agreed before the learned single judge also 7 days.
No. I mean, Mr. Bhuyan,
My-
these are the documents that you will bring to the notice of the government now.
Other documents are also there.
What other documents? This way you will continue
No,
forever.
no, my lord, those will produce before the authority. My lord, at least one chance may be given to the appellant, my lord. So as my lordship has taken a uniform policy, my lord, these are, my lord, absolutely, my lord, these people are, my lord, in such a condition, my lord.
Mr. Boyan, the
My lord.
difficulty is,
My lord.
what you're saying is not very, very ingenuine. But then it'll unnecessarily linger the process.
No, my lord may fix a certain date, my lord. After date.
For you, it is not there. For you, 21 days have left.
As the matter has come up before my lordship can have a mercy on these people also.
For how long?
My lord,
Mercy for
my
how
lord,
long?
for a particular period only, my lord, these are so marginalized, my lord, I am constrained to say, my lord.
Mr. General, I think.
lord.
Lordship,
you two-
everybody has left. Everyone has left except this. This is a statement here in my
you
affidavit
have made
also.
that.
No, my lord.
Everyone has left without any
For
difficulty.
others,
Hmm.
the other persons, the next from henceforth,
My lord.
the state will give 15 days notice,
Well.
7 days notice, 7 days further time to explain, and then within 15 days they will decide.
Lord.
My lord, because these people are also having some materials, articles in their houses now, my lord. They are expecting that my lordship.
If they are waiting for the
May-
harvest,
No,
then
no,
that is a
Lord.
different
No,
story.
no, my lord, harvest is there, my lord, harvest is there,
That happened in Lumding when this honorable court directed us to remove
If
the
we cannot
enforcement in Lumding
live there,
reserve
there is
forest.
no meaning of harvesting lands also there, my lord. We are
Here
not
fish
interested.
are there,
My lord.
beetle nuts are there.
No, my lord.
On affidavit, we have said that.
It is,
And
my
we can
lord,
produce the photo and videos also. There were commercial establishment, one sort of a mall was also there.
no.
It was all, everything is removed now.
No, my lord, mall is not there, my lord.
Sort of a mall. We have no objection if lordship gives that opportunity, the 7 days, 15 days, lordship, no difficulty. And also one observation regarding the officers who are responsible for.
That is necessary.
Yes, lord.
All this is creating.
Yes.
In the all forest.
In fact, they are hand in glove in most of the cases. Not now the present ones, the earlier ones.
All forestmen should also be clear. No,
Yes.
yes. Yeah. Political person. এগুলো সব politics. Political leader করা যায়। আমি বুঝতে পেরেছি, হ্যাঁ, কংগ্রেসের নিয়ে মহাকাল বলি আপনার চাকর কানিয়ে দিচ্ছে। কংগ্রেস নয় এসিপিও। এই অরুণ পরমারা ওনাকে বানানো লাগছে দিয়ে জানিয়ে দিচ্ছেন। এগুলো করতে নেব না বিফল হবে। Some reference, some implementation of this.
Take down.
Can I have?
59 of the appellants had challenged the notices issued to them dated 24/7/2025, asking them to vacate their lands within 7 days. The land in question fell in the reserved forests about which there is no dispute. The challenge was made on the ground of non-adherence to section 18(2) of the Assam Land and Revenue Regulation 1886, as also violation of Assam Land Policy 2019 and guidelines of the Supreme Court in its order dated 13/11/2024, passed in WPC number 295 of 2022. The learned single judge, while dealing with the case of the appellants, found that they deserve a window of 7 days to a bigger window, and not only of 7 days, to vacate the land in question. Not satisfied with this, the appellants preferred an appeal. Preferred an appeal. This court on 5/8/2025 noted that in any reserved forest, any act of clearing of forest by an encroacher or setting fire or continuing with any activity is strictly prohibited. There could be no way in which the land in reserved forest could be used for any purpose whatsoever. While hearing the appeal, this court also noted the submissions of the learned Advocate General that in the state of Assam, 29 lakhs bighas of land in the reserve forests have been occupied by encroachers. And because of the intensive drive undertaken by the state government to remove such encroachments, more than 1 lakh bigha of land has already been cleared from encroachment. It was only as part of the same anti-encroachment drive that the notices impugned in the writ petition were issued to the appellants. The consistent stand of the appellants has been that they are / have been residing in the houses constructed long time ago with government funds over the allocated land. Since such statement was not supported by any affidavit or proof, this court directed the appellants to come up with any possessory / title documents to substantiate their claims. Even though the stand of the state was that the Doyang and Namba reserve forests were notified about 100 years ago, and that the appellants had never made any claim for settlement or any right for zoom cultivation, such claims of the appellants were absolutely bogus, we asked the state also to furnish requisite affidavit stating about the procedure for evicting the encroachers from the reserved forest land. The state has consistently harped upon the fact that the forest area in question has been clearly demarcated, and only such persons who are found to be residing in such demarcated reserve forest area have been issued notices. It was also clarified before us that for removal of encroachment from the revenue land of a state, there is a specific procedure. But since no activity under any circumstance is permissible in the reserved forest area, the rules and regulations in that regard do not prescribe of any specific procedure for evicting encroachers from the reserved forest land. With respect to the appellants, the state has made a categorical statement that none of the appellants are either flood affected or landless or forest dwellers. Semicolon, rather they are squatters and encroachers, who by their continuous illegal activities and who by their continuous illegal presence inside the reserve forest area and illegal activities have caused sufficient damage to the natural habitat of such forests. So perhaps their stay inside the reserved forests would tantamount to letting them succeed in their plans of capturing the forest land in a designed way which would ultimately have a devastating spiraling effect, causing complete ecological apocalypse. Pursuant to our directions on 5/8/2025, the state as also the appellants have filed their respective affidavits. The affidavit on behalf of the state sworn by the Principal Chief Conservator of Forests and Head of Forest Assam. It has been stated that even in the absence of any procedure for eviction of encroachers from reserved forest land, the appellants were issued notice intimating them that they have illegally entered in the Doyang Forest Reserve and are required to evict and are required to exit from the forest areas within 7 days. Stop. The affidavit further declares, affidavit further elucidates that the regulations 24 and 25 of Assam Forest Regulation 1891 provides for penalties for trespass and damage to any reserved forest. In this view of the matter, there cannot be any question of permitting any encroacher to reside within the demarcated reserved forest land. Even if for some inaction on the part of forest officials, some persons were allowed entry in the forest reserved forest area who continue to stay there, they would have no rights to enforce against the government when such eviction drive is undertaken. With respect to the particular reserved forest of Doyang, the affidavit of the state clearly indicates that till date, 320 dwelling houses and other structures illegally erected have been cleared. Have been removed, and about 400 bighas of reserved forest land have been made encroachment free. According to the information received, the appellants and many other similarly situated persons were indulging in commercial farming of betel nut trees and had also set up fisheries. This appears to us to be shocking. First off, it really calls for a total revamp and rehaul of the state mechanism to prevent any such infiltration in the forest, in the reserved forest areas. We will get back to this issue later after having dealt with the affidavits of the appellants. Another shocking fact disclosed in the affidavit of the state is that some commercial shops were also found existing inside the forest area. Those fortunately also have been dismantled during the period of this anti-encroachment drive. Apart from the appellants, the contention of the state is that all other encroachers in the area in question have already made their exits and have returned to their original native places in the districts of Nagaon, Morigaon, Kachar, Hailakandi, Barapeta, etc. In opposition to the aforementioned affidavit, Mr. Bhuyan, learned advocate for the appellants, has filed an affidavit in an attempt to demonstrate that there are no encroachers, but legal settlers on the houses, legal settlers of the legal settlers, and have been residing in the houses constructed out of government fund unless under some beneficial schemes. They have been provided with all facilities of water, electricity, etc. under the Rural employment guarantee programs. Stop. Few of the allotment letters have also been brought on record, which pertain to some of the villages. However, on a perusal of those allotment letters, it appears that those are for houses in villages which fall under Mirapani Gaon Panchayat and not inside the reserved forest area. The contention of Mr. Bhuyan that there being allottees under this scheme presupposes that necessary verification would have been made by the government after geotag photography of the land in question. And hence, without a fresh demarcation of such villages from the reserved forest area, such eviction drive cannot be given effect to lock, stock, and barrel. True it is that a government scheme would not have come into existence without verification whether such facilities are made available outside the reserved forest area. But does not explain or vindicate the claim of the appellants that they are not residing inside the reserved forest area and that the eviction notices are bad in law. Details of the various services and benefits provided to the appellants have been enumerated in the affidavit, but without any specific assertion that the houses in which they have been residing are not in the demarcated reserved forest. On the contrary, a map has been brought on record by the state, signifying a clear demarcation of the reserved forest land and the peripheral revenue lands of the state, revenue land of the area. Stop. Even assuming that some of the houses constructed out of government fund was the residential place of the appellants. But if it falls / fell in the reserved forest area, that needs to be removed, which would only be in consonance with the relevant rules and the regulation with respect to forestry. The learned counsel for the appellants thereafter submitted that the appellants have been cherry-picked for being evicted, whereas other encroachers in the same area have not been disturbed. Perhaps, perhaps on account of their hailing from different community. This argument has no legs to stand for the reason that there is no proof of such assertion. And even if it were a fact, it would not justify the presence of the appellants in the forest, in the reserve forest area. In this context, we would like to direct the state to ensure that a proper check mechanism is put in place which would prevent any illegal entry in the reserve forest area. It could be by way of checking the entry points, putting barbed wire at porous borders, and setting up of functional checkposts. All this would become effective if only if the officers slash persons managing such checkposts do their job honestly as also efficient. In all fitness of things, the state must come up with necessary regulation in that regard. And if ever it is found that such entry of such illegal entry in the reserve forest area is because of some collusion of the forest officials and the authorities, or even the ministerial staff, necessary penal action should be initiated against them as well. In fact, if the state is serious about preserving the pristine forests / reserved forests of the state, it would come out with a regulation whereby even the officers of the forest department, even the officers and ministerial staff of the forest department would be held responsible for any unauthorized / illegal entry in such reserved forests. A review of the situation periodically would further help build a kind of institutional mechanism for preventing such unauthorized entry in the reserved forest areas. Constant surveillance of the reserved forest area would also be required to ensure that the encroachers again do not enter the reserved forest area and spoil the ecological balance. We would also like to observe in this context that henceforth, if such drive is taken for clearing the reserved forest area of all encroachment, and it is found that there are some settlers, even though unauthorized, they ought to be given a reasonable period of time, say 15 days, to explain under what circumstances have they set up their residence inside the reserved forest area where any non-forest activity or their presence attracts penal offense, and a further period of say 15 days for exiting the place on being asked to do so. Notwithstanding the fact, as a next start period, notwithstanding the fact that there is no procedure delineated in any one of the regulations concerning the reserved forests for, what have I said? Notwithstanding no procedure, notwithstanding evening, notwithstanding any procedure, notwithstanding no procedure having been delivered, it would only be in the interest of justice that a notice of 15 days and a further time of 15 days be given to such squatters / encroachers to leave the reserved forest area. The learned advocate general raises no objection to such an observation and submits that effort would be made to put such procedure in place for any future eviction drive. Correct?
Yes, and one more thing, that this will not dilute that the state cannot proceed against them under the penal provisions of the regulation.
Yes.
That may be clarified, Lord. Otherwise, they said we are allowed to go, so they are
No,
free
no.
from all prosecution.
However, this would not protect the encroachers from being prosecuted for the penal offense committed by them in staying carrying non-forest activity in reserve forest
Under section 24.
under regulations 24 and 25 of the
Yes.
Assam Forest Regulation 18 so and so.
Yes.
The officers should also be penalized.
That we have said.
At the
That
very
yes.
beginning.
After having said so, we find that no good ground has been laid out by the appellant in differing with no good grounds have been raised by the appellants for us to interfere with the judgment of the learned single judge.
That was the interim order.
It
is interim order.
Wisdom had, who in his wisdom had passed an interim order giving a bigger window to the appellants to vacate the forest area. Thus, we also close the writ petition. Number so and so. Finally.
There are other prayers in the petitions also.
Well, that stands closed. The other prayers, it'll be open.
Can be adjudicated, my lord. Rehabilitation.
You can file a fresh petition for resettlement or whatever.
Then my lord may give that liberty.
Stop. In case the appellants have any other fresh or different cause of action, they may approach the court for the needful.
My lord, we are also entitled to that extended period, my lord, 15 days, my lord.
Finished. That is over. 21 days is over. Now you must vacate.
That
My lord,
may be
at least-
clarified.
My lord may at least given, my lord.
We hereby clarify
My lord.
that we have already given more time. We have already given an extended period to the appellants to make good their exit from the forest area. Full stop. Full stop. If the appellants do not leave the forest area within a further period of 7 days
My lord.
to be counted from today, the state would be absolutely, the state would proceed against them for eviction.
My lord.
Highly advised, Lordship.
Arjuna Praja, Parva, Bhaskar, Ji, Appa, Panya,
We accept that we'll dismiss for correct. Both the appeals stand disposed of accordingly.
My lord. Obliged, my lord, highly obliged, my lord.
Item 19,
Mr. Advocate General, I think if that is left, Mr. Advocate General, please have that regulation because it's because of the collusion of the forest authorities,
Yes, yes,
ministerial staff.
Not only, there are other district administration persons are also involved.
They should be prosecuted.
And also, Lordship has not said some politicians of the.
That
My lord, the other
The
person.
main thing, it started in the 1930s onwards, not here. So various political persons,
No, no,
or irrespective
no.
of any color and hues, lordship, I'm saying.
No, Mr. Bhuya, we must admit, any indulgence at this stage
My lord,
would cause further problems.
that is correct.
This is
That's
the
why, my lord,
maximum that we have given.
my lord, may I give an another direction that there should not be this eviction drive should not be based on some selective manner. All persons should be cleared.
We have
They will also.
classic example in Guwahati itself, in
No, my lord.
Siltako.
That is correct, my lord, but
Yes,
in
that he
that
have to
area,
admit, he have to
Yes.
admit. We are not selecting any community or any religion.
that is
lordship.
there, my lord. It is
Very
correct.
genuinely Article
Okay.
14 and 16 are followed.
Yes, we have no.
Highly
Obliged,
obliged, lordship.
obliged.
Yes,
My lord, to the petitioner, my lord, may I just indicate the brief factual background?
yes,
2007, my lord, the petitioner was appointed as a postal assistant, my lord.
yes,
And while he was working as a sub postmaster at Dharam to Lesso,
yes,
there were certain discrepancies which were found, my lord.
yes,
And the department wrote two letters, one on 27 to 2012 and the other on 29 to 2012, intimating me that in certain accounts there were certain discrepancies. And since I was working as a sub postmaster to shoulder the responsibilities, my lord, I have paid the amount. I repaid the amount to avoid any complication in the matter.
That's under wrong advice.
My lord,
It's always paid under protest, number one, and number
Yes.
two, it's normally avoided. Otherwise, you accept your guilt.
that is one way, my lord. The other way is like, my lord,
All
to
right.
avoid any complication, my lord. But may I just,
You have got the complication.
my lord,
You have paid 70,000 rupees, 71,000 rupees.
I have
and
paid.
You have secured your removal from service.
my lord, he paid to avoid any complicancy, and my lord, there was no loss to government exchequer. My lord, despite such, my lord, a show cause notice was issued to me, which your lordship will find at page 41, my lord. Page 41. The first few lines, that the said Sri Pankaj Sakya, while working as SPM Dharamtul for a period of so and so, my lord, accepted a sum of so and so only from SDRD depositors as details on various dates and made entries of the deposits in the relative passbooks with necessary date, stamp impression of the office of the for the respective date of deposit, but he did not credit the amount so accepted in the accounts of the SO on the very dates or subsequently. And as such, he was charged. And I submitted, my lord, my written statement, inter alia stating that I had not misappropriated in government money. And thereafter, my lord, an enquiry officer was appointed. He conducted the enquiry, my lord, and the enquiry report, my lord, will find at page 92, my lord. Page 92. In
Yes.
fact, that is the conclusion at the bottom, page 92. And the operative portion, my lord, will find at page 93, my lord. In the middle, the enquiry officer's signature, AJ Talukdar, is there. And fourth line from bottom, my lord, in the middle. And the case is therefore returned to the disciplinary authority with the findings that the charge framed against Sri Pankaj Sakya, the then SPM Dharamtul SO and now PA Difu, under Superintendent PA, Nagaon Division, Nagaon, stands proved and established beyond doubt. Now, this was the finding of the, my lord, enquiry officer, my lord. And the stand of the department, my lord, will find at page 217, my lord. If your lordship kindly turns to page 217 for a moment, this was the written statement which was filed in the learned court below, paragraph 7, my lord. Paragraph 7, may I just read out?
Yes.
That with regard to the statements made in paragraphs 4.K, 4.L and 4.M of the OA, the deponent begs to state that the applicant was booked under section rule 14 of the CCS rules, wide SPO's Nagaon division memo number so and so. The respondents further beg to state that since the charges framed against the applicant was proved beyond all reasonable doubt.
You're reading paragraph 7.
My lord, paragraph 7, my lord, page 217, my lord.
Yes.
My lord, third line, my lord. Third line says, this is the stand of the government. The respondents further beg to state that since the charges framed against the applicant was proved beyond all reasonable doubt, so there is no question of exonerating the applicant considering his length of service and experience, etc., as paid for the applicant, my lord. Now, my lord, your lordship is aware, the standard of proof in disciplinary proceeding is, my lord, preponderance of probability. It is only in the criminal trial, my lord, the standard of proof is beyond reasonable doubt.
No, this is a written statement on behalf of respondents in the.
Of the authorities, my lord. This is how they justified.
No.
It tallies with the inquiry report, my lord.
This is no ground for us to see, no?
May I just indicate, my lord?
In fact, the rules of High Court would tell you that these are not to be, I mean, this can be part of record, but this can't be made a special annexure.
Well, in
These are
any,
statement of facts, means
No, well,
nothing.
what I was trying to impress upon your lordship,
Let's see the order of the cat.
my lord. Order of the cat, your lordship will find at page number 227, my lord. It starts at 227. And the relevant portion, my lord, will find 235. In fact, 234. Page number 234, my lord. Paragraph 10, operative paragraph, my lord.
Just.
My lord.
No, there's some factual mistake. Read paragraph 2. The facts in brief are that the applicant was appointed on compassionate ground to the post of postal assistant on 21/2/2017. Can't be, no?
My lord, page 234, my lord.
No. They are asking you for something else.
My lord.
Page 234, 29.
229, my lord. 229, my lord.
So can't be, no? Because the charge, the memorandum of charge is dated 2013.
Yes, my lord. Yes.
So it must be 21/2/2007.
My lord.
17.
29/4/2013.
7.
7. This is a typo, perhaps a typographical error, my lord.
Let us see the article one of the charge.
My lord. That article, my lord, will find at page 40.
Let's see what has been called out in the order.
My lord.
At page 229.
229. That, my lord, will find, my lord, at page number, paragraph 2, my lord. Page 229. May I just read out, my lord?
Yes.
The facts in brief are that applicant was appointed on compassionate ground to the post of the postal assistant on 21/2/2017. My lord, that's
Read article number 1.
the charge. Article 1. That the said Sri Pankaj Soikia while working as a SPM Dharamtul SO for the period from 6/12/2010 to 26/10/2011 accepted a sum of rupees 44,060 rupees only from the SBRD depositors as detailed in the enclosed list on the various dates and made entries of the deposits in the relative passbooks with necessary date stamp impression of the office for the respective date of deposit, but he did not credit the amount so accepted in the accounts of the SO on the very dates of the deposits or subsequently. By his above acts, Sri Pankaj Soikia violated the provision of Rule 31(2) ABC of the Post Office Savings Bank Manual Volume 1 and also showed gross lack of integrity and devotion to duty and also act in a manner which is unbecoming of a government servant, violating the provision of Rule 311, 312 and 312 of the CCS rules 1964. But this is the charge. And my lord, the department did not stop there. I was dismissed on, my lord, 35/2014. I preferred a departmental appeal, that was rejected. I preferred a revision petition, that was also rejected. And the department didn't stop there, my lord. Department went on to file an FIR against me on the basis of same incident on 22/9/2016. And this is what the, my lord, learned judicial magistrate first class Morigao had to say. My lord will find that order at page 236, my lord.
Just.
My lord.
Yes, you're saying something.
My lord, after my dismissal, my lord, I
Dismissal or removal?
removal, my lord. I approached the authorities by way of an
Appeal was dismissed.
appeal was dismissed and revision was also dismissed. Thereafter, they did not stop, my lord. On the basis of same incident, they filed an FIR against me. And this is what the learned court below had to say, my lord. Page 239, it starts, and relevant portion, my lord, will find at page 247. Page 247, my lord. That is the operative portion, paragraph 21. May I just read out, my lord? Page 247, my lord.
That's
So they say
this is beyond all reasonable doubts. This is preponderance of evidence.
exactly, man. That is my point. Had the standard of proof in the departmental proceeding was preponderance of probability, I would have had no case, my lord. I have not come before your lordship. But since in this case, my lord, the standard of proof was beyond reasonable doubt, both in the DP as well as in the, my lord, the criminal trial.
Just the opposite of law which has been laid down for so many years.
My lord, I'll try to convince your lordship, my lord.
No, that's absolutely against the settled proposition of law. That these are two different separate proceedings.
Exactly.
You can't,
Exactly.
two principles.
Exactly.
You can't take that plea.
Well,
You can't take that.
well, all I'm trying to impress upon your lordship is
Disproportionate. Disproportionate law, yeah. If it shocks. That money inexperienced. You were appointed in 2007.
7, my lord.
And this occurrence took place sometimes in 2013.
My
You are
lord.
no longer that inexperienced. You are not a greenhorn.
Well, for the post of some postmaster, I was. Initially, I was appointed as postal assistant. Then slowly, my lord, I got promoted. So
You were there.
at the time of incidents, I was very inexperienced, my lord.
Look at this. You did not deposit it immediately. You know, you also cared to deposit 27,000 more by way of interest. So
Interest.
the deposit would have been much after it was detected. So you had mentioned everything, pocketed it.
My lord, the moment they detected, they gave me 2 letters.
You can argue about disproportionality of these things.
I deposited it before even issuing the show cause notice, my lord. At the first instance, the moment they showed me the discrepancy is the moment I deposited the amount, my lord. Had it been an experienced person, my lord, he would have never deposited.
Departmental proceeding, you did not do anything. You did not take any witness. You did not examine yourself. You did not ask for anything. Only before the cat, you wanted certain documents to be given to you. You gave, those documents were given to you. So under what law, what provision
May-
to be invoked?
May I just place the, my lord? Come on, dear.
That.
Lord, this is a latest judgment, Honorable Apex Court, my lord, Ramlal versus State of Rajasthan, 2024, 1 SCC 175. I'll just point out the relevant portion. Paragraph 9, my lord. 2 questions were framed by the Honorable Apex Court. The first question was, paragraph 9A, whether the dismissal of the appellant from service pursuant to the departmental inquiry was justified. And question number 2 was, on the facts of the case, what is the effect of acquittal ordered by the appellate judge in the criminal trial on the order of dismissal passed in the departmental inquiry? Now, the answer to these questions are at paragraph 13, my lord. May I just place paragraph 13? It says, however, if the charges in the departmental inquiry and the criminal court are identical or similar, and if the evidence, witness, and circumstances are one and the same, then the matter acquires a different dimension. If the court in judicial review concludes that acquittal in the criminal proceeding was after full consideration of the prosecution of evidence and that the prosecution miserably failed to prove the charges, the court in judicial review can grant redress in certain circumstances. The court will be entitled to exercise its discretion and grant relief if it concludes that allowing the findings in the disciplinary proceedings to stand will be unjust, unfair, and oppressive. And the appellant was granted relief in that matter, my lord. Here, my lord, basically deduction from GM tank, my lord. No, my lord.
Ranjit Thakur का केस था Ranjit Thakur because they proportional this is proportional of citation here judgment by TS judgment by TS yes. What do you have to say?
You have given every opportunity, my lord, and he himself admitted, my lord. So for my lord, is one of these, my lord, they to letter represent to the superintendent of postal service. This is, my lord, page 94. The relevant portion is 96. Here is, my lord, the explanation, my lord, is paragraph 7. There is no habitable SP SPMS quarter at Dharamtul. Quarter was not there, so he was not there. There was no rented house to stay. These are the explanation. Therefore, I had to perform duty from my residence at Nagaon, which is at a distance from 50 kilometers from so and so. And next, the Dharamtul sub office is being cleaned by the part-time who attends in the morning. Does the key with some ZDS, MC, and ZDS plus paper of the SO who are the local staff of the SO? They used to accept deposit. They accept deposit of RD. Deposit accept they used to accept the deposit RD and SB account from the members of the public as and when I had attended.
That's all right. You were dismissed when?
My lord, I was dismissed, my lord, on 30/5/2014, my lord.
11 years have passed by.
It's a young boy, my
We
lord.
are contemplating of sending it back to the disciplinary authority, but then it serves no purpose. 1 year, 2 years, 3 years. 11 years you're out of service.
And this judgment of the learned
And
trial,
this criminal, and you would have filed this only after your acquittal.
no, that acquittal is 22/5/2025, my lord. Very recent, my lord. 22/5/2000.
When did you file the OA?
OA, my lord.
16.
16, my lord. And dismissal, my lord, 12/2/2020. 12/2/2020, my lord. The order of the learned.
Yes, my lord. Thereafter, my lord, there's 25, my lord. After 5 years, file.
No, no, 82 চলি আছে এখন। Criminal তো আগৰ পৰাই চলি আছে।
No, it.
It has been a long time. We were inclined to remit it to the disciplinary authority to take a fresh call on quantum. But
My lord, if your lordship sees, my lord, that FIR was in 2016, but judgment is just now, my lord.
That's
My lord-
right.
my lord,
Yeah.
here, first the-
We are not blaming you, we are blaming the circumstance. We
Circumstance.
are not saying that you're coming late,
Circumstance.
but for you to have remained out of service with the punishment of removal,
And,
whether it would be appropriate.
and he's just 39 years old, my lord, this person, my lord. So it can be remanded, my lord. They'll take a fresh call.
My lord, this, the cat order is, my lord, to 2020, and certificate copy was obtained, my lord, on two thousand
We are
twenty.
not on that. We are only on the passage of time.
Yes, yes, my lord. So, my lord, after 5 years, they filed this
After?
5 years, my lord. Is representation.
No, no, no.
No.
Let me tell to 2025.
I understand.
And affidavit page 30, my lord, he's 39 years old. He might get a second chance in life, my lord.
Here,
No, nothing you can do.
And
the other case, my friend, this citation was there, there is, my lord, maybe, my lord, in disciplinary procedure, he denied, my lord. Here, my lord, in all stages, he accepted, my lord.
and
He accepted that, and the so-called criminal cases is beyond reasonable doubt, my lord.
and one
So that case may not be applicable in the present case, my lord.
and one page perhaps which deserves your lordship kind attention is page 253, my lord. If your lordship kindly turns to page 253 for a moment. Serial number 27, my lord, is certified copy memo of charges. Serial number 28, copy of the departmental inquiry report. Serial number 29, that is the penalty order. So all these materials were before the London trial court below. And after that, my lord, after hot contest, so judicial finding will precede over the quasi-judicial finding, my lord.
My lord, he was waiting.
That argument doesn't hold us back even from it. We have heard Sri A.K. Barua, learned advocate for the petitioner, and Mr. S.K. Medi for the respondent. The challenge in this writ petition is to the order passed by the CAT, whereby the punishment imposed upon the petitioner in a departmental proceeding has not been of removal from service has not been interfered with. The petitioner was appointed on compassionate grounds in the year 2007 on the post of postal assistant. A disciplinary proceeding was initiated against him in the year 2013 with the specific charge of not having deposited rupees 44,060, which he had collected from depositors in the bank. Such action, therefore, was found to be unbecoming of an officer of the post office as it showed gross lack of integrity and devotion to duty. The act of the petitioner was found to be unbecoming of a government servant, violating the provisions of Rule 3, bracket 1, then bracket Roman 1, 3, bracket 1, bracket Roman 2, and 3, 1, bracket 3 of the CCS bracket Conduct Rules 1964. It appears from the records that though the petitioner participated in the inquiry, but never produced any evidence in support of his defense, nor got himself examined, even though he was made to understand that he could have done so. He could have done so. He also did not produce any evidence, produce any witness in support of his defense. All the defense that he took before the disciplinary authority was that because of his inexperience, a discrepancy had occurred, which was largely because of oversight. But no sooner had he come to know about it, he had deposited the amount in question, along with additional amount which could have been the interest on such amount which was not deposited in the first instance. It appears that after the petitioner deposited the amount so stated to have been defalcated by him, he was subjected to a departmental proceeding in which he was subjected to a penalty of removal from service. The appeal and the revision against such orders did not succeed. The land counsel for the petitioner has further submitted that as a vindictive measure, despite the petitioner having deposited the said amount before the departmental proceeding was initiated against him, he was made accused in a criminal case in which he was put on trial. However, the trial court, let's see the trial court judgment.
My lord, that is at my lord, it starts at page 240, my lord. Page 240. And operative portion, my lord, will find at 247. 240 it starts, my lord, the judgment. And materials relied on 253, my lord. So-called departmental inquiry report, penalty order, everything was examined.
Trial court found no incriminating material against him to charge him with the offense under section 409 of the Indian Penal Code. Since the prosecution had failed to prove the case against the petitioner under section 409 of the IPC beyond reasonable doubts, the petitioner was acquitted of the charges. The land counsel for the petitioner therefore submits that the charge against him in the departmental proceeding, as also in the criminal case, were identical. The law with respect to this aspect of the matter is too trite to be recorded here. A disciplinary proceeding and a criminal case are dealt with differently. In a criminal case, the charges have to be proved beyond all reasonable doubts. Whereas in a departmental proceeding, decision hinges on the probability, on the preponderance of probability. However, if the charges in departmental inquiry and the criminal courts are almost identical and similar, and if the evidence, witnesses and circumstances are one and the same, in certain cases, it might acquire a different dimension. It might require different. Under such considerations, under such circumstances, a court might be entitled to exercise its discretion and grant relief if it concludes that the findings in the disciplinary proceedings to allow to be allowed to stand would be unjust, unfair, and oppressive. However, there is a caution in applying this rule that every case will turn on its own facts. Refer to GM Tank versus State of Gujarat and others. 2006, 5 SCC 446. State Bank of Hyderabad versus P. Katarao. 2008, 15 SCC 657. And Ramlal versus State of Rajasthan and others. इसकी citation खुद भी लिख लेना. इसमें Manu SC 13. Manu/SC/1305/2023. The petitioner cannot claim that he was not given a fair deal in the departmental proceeding. In fact, he was made to understand that he can examine himself, produce witnesses, or bring any document in his defense. But he never chose to do so. However, what strikes us, what has struck us is that he was appointed on compassionate ground, and that before the departmental proceeding was initiated against him, he had deposited the amount in the treasury along with interest. Just of that apart, he had not forgotten to make such entries in the relevant records, which is a substantial proof of the fact that he did not want to act surreptitiously in this matter and avoid depositing the amount so collected from the depositors in the treasury, or else he would have avoided to make such entries in the records. These aspects make us feel that the punishment of removal from service, especially when he is only 39 years of age as of now, is disproportionate and unduly harsh, which requires a review. We are conscious of the fact that a judicial review of the disciplinary proceeding, generally speaking, is not directed against the decision, but against the decision-making process. The question of choice and quantum of punishment is within the jurisdiction and discretion of the disciplinary authority. But after having said that, we do not wish to forget that the sentence has to suit the offense and the offender. It ought not to be vindictive or unduly harsh. It should not be disproportionate to the offense so as to shock the conscience and amount to conclusive evidence of bias. Though the doctrine of proportionality in disciplinary proceedings is of a late origin, but in a case of this kind, we are of the view that the sentence imposed upon the petitioner ought not to remain immune from correction. Though many years have passed, next paragraph, though many years have passed by and the petitioner has remained out of service for about a decade, but taking into account that he is still 39 years of age, we deem it appropriate to set aside the sentence imposed, the order passed in appeal, revision, and the order passed by CAT, and remit the matter to the disciplinary authority for giving a fresh look and take a decision with respect to the quantum of sentence to be imposed upon the petitioner, keeping in mind his age, his effort at restituting the money which could not be deposited because of oversight, and that he had not, and that the petitioner had made relevant entries in the records, leading to the presumption that there could not have been an attempt at swindling the amount for personal use. Personal use. The decision by the disciplinary authority in that event shall be taken within a period of 8 weeks by a reasoned order, within a period of 8 weeks from the date of receipt of the production of a copy of this judgment. The order so passed shall be communicated to the petitioner forthwith. We also, however, clarify that if the disciplinary authority concludes that lesser punishment ought to be awarded to the petitioner, no back wages shall be granted to the petitioner as he has remained out of service for all this period. With the aforementioned directions and observation, the writ petition stands disposed. We have exceeded our jurisdiction, but nonetheless, we have done it for the interest of the justice.
Words cannot express my gratefulness, my lord. Deeply obliged.
All right, yes.
Item 20 and 21.
In item 20 and 21, my lord, today I have received the affidavit, copy of the affidavit, signed affidavit, my lord. Tomorrow I will filing it, my lord.
You have received what?
Copy of the signed affidavit from the department.
Okay.
Tomorrow morning I will file it, my lord.
Is what? You are standing counsel for secondary
Secondary
education.
education department. NJ Khataniar, my lord.
NJ Khataniar.
Yes, my lord.
Mr. NJ Khataniar, learned standing counsel for the Secondary Education has submits that written instructions have been received by him only yesterday. Stop. He wishes to file a detailed counter affidavit in the matter. Stop. For the aforesaid purpose, he seeks a short adjournment. Re-notify 3 weeks.
No, I've already received the signed affidavit
So when do you want it? 2 weeks.
after 2 weeks.
My lord, some urgencies there, my lord. Matter relates to selection and appointment.
1 week.
Yes, my lord.
Oblige, my lord. Oblige.
5-9.
One. 5.
Supplementary list, item 26.
May it please your Lordship.
6.
Lordship, this matter is a review petition, my lord. We have filed this review petition assailing the order dated 7/8/2025, my lord. 7/8/2025 passed in WP writ appeal number 414 of 2024. My lord, there are certain this review petition, there are certain aspects which we are aggrieved by, my lord. That is at paragraphs 7, 9, 10, and 11 and 12 of the order dated, which is at page
Yes, order is before us.
335, my lord. It starts at 335. My lord, here, the first and foremost thing which we would like to, my lord, highlight, my lord, is that at paragraph 9, my lord, it is the case of the respondents in general that a composite reading of the rule 1125 with rule 32A and B would demonstrate that by way of executive instruction, a decision could be taken to encadre any post as a feeder post for promotion to any of the cadres mentioned in subrule 1 and subrule 2. It has therefore been contended that the case of the respondent number 7, a translator, is covered under rule 32A and B and of the 1986 rule. Now, my lord, this is a rule. Now, my lordship will kindly have the rule once. That is the 1986 rules, which I have given it to the.
Who appears for the other side?
My lord, the government is appearing and the APSC, my lord, they are
And who is
appearing.
the private party?
My lord, the private parties have not filed any caveat, so we have not, they haven't filed any caveat in the matter.
They have to be served notice.
My lord, but they have not filed a caveat.
Doesn't matter.
My lord. Well, sir, my lord, just one thing I just want to point out, my lord, before that, my lord, just one thing. My lord, before this thing, I just want to point out one thing, my aspect, my lord. If your lordship kindly takes up the rule at page 4, my lord, page
That's
4.
right. We'll hear it only in the presence.
Yes, your lordship, but
Like notices we issue to.
well, till
As a legal notice to response number 1 to 5 is accepted by Mr.
DK Sharma.
Huh? By
DK.
Mr. DK Sharma, learned advocate for the state. Stop. Let notices be issued to response number 7 to 11 on steps being taken by the review petitioner
I'll serve them.
within a period of 2 days. You will serve it dusty.
I'll give it Dustin because their advocates are there only, man. But they didn't file, that's why I didn't give them.
Notice to respond number 6 is accepted by Mr. Mahanta, learned senior advocate for Assam Public Service Commission. The learned counsel for the petitioner submits that he shall inform the learned advocate who had appeared for response number 7 to 11 in the writ petition, in the writ appeal. In the writ appeal. Let this matter come up for consideration on after a week.
Lordship, just one prayer, your lordship. There is an apprehension, we had a stay in this matter in the writ appeal, that one post was left vacant for us, my lord. There is an apprehension they're going to fill it up. That is why we have filed the review in the as soon as possible.
The hands of the
So my
clock
lord,
can
my lord will keep a status quo, my lord, because there is a apprehension that we'll miss the bus. Your lordship.
let the other side appear.
My lord, then my lord, can it be taken up on day after, my lord? Day after will be, my lord, because there is one small issue is there, my lord, regarding 3 to A and
Doesn't
P,
matter. Doesn't
my lord, the stay, if you don't, one till then.
Prayer refused.
My lord, status quo, my lord.
Prayer refused.
My lord, because my lord will be prejudiced, my lord. I know that's why we have come, my lord. On 7th, it was fine. We have got it today, my lord.
Now you will have to make out a case for review, no?
My lord, the 3 to just once. If you
Anyway, we have given you a short date. We have permitted you to inform the other side.
My lord, they will appoint them. They will give them promotion otherwise.
Sorry, we have
just one point, my lord. And one more.
No status quo.
3 to A and B.
Whatever, nothing is, heavens are not going to fall in 1 week.
Because my lord, they will give the promotion.
No, Mr. Counsel, no. We have said.
My lord will record that, my lord. Kindly, my lord.
Please. Yes, next.
27 it. Item 27.
May I please, your lordship? Lordship, this matter pertains to default in repayment of EMI, lordship.
That's right.
15
You
CR.
wanted it to be upgraded to standard assets.
Yes, lordship.
What do
but
you have to say?
Before submitting my submission, your
Okay.
lordship, one aspect I would like to direct your lordship attention, your lordship. On the last occasion, your lordship, the observation was there, appeal has been disposed of, your lordship. But to be very honest, your lordship, here my
What is
application under section 17 has already been dismissed, your lordship. Appeal is yet to be filed, your lordship, but because my prayer is limited to not upgradation of my account to standard
Then
asset.
perhaps we might not hear you. You should file an appeal.
No, your lordship, what happened? Because the
Just
on
that
the
you'll have to deposit some amount.
deposit some amount and your lordship on the maintainability
So
grounds,
therefore,
your
let
lordship.
them say whatever they have to say, otherwise you go in.
Lordship.
Yes, what is your,
Your lordship, their surface application has already been dealt with and dismissed on 18/7/2025.
that we know, no?
And your lordship, as far as their dues is concerned,
No, one thing. They say that after that, there are default of payment of 13 EMIs.
not 13, your lordship. There was an incomplete set of facts, your lordship.
You file your response. Mr. Who is he? Mr. M. Sharma, learned advocate for the respondent, submits that by the next date, necessary affidavit shall be filed. Re-notify 1 week,
Your lordship, 2 weeks maybe.
2 weeks.
5-9. Daily list for hearing item 24.
May I please, your lordship?
Yes.
On the last occasion, lordship made a query. This is regarding their service conditions, lordship.
Yes.
Whether the
Have you
respond-
filed counter affidavit?
Lordship, I have received the instructions on 14th. Lordship, allow me 1 week's time, I'll bring it on record, lordship.
Mr. RKD Chaudhary, learned deputy SGI,
Lordship.
seeks some more time to put in the response. Let this matter come up for consideration. Again, after 3 weeks. But 3 weeks का मतलब नहीं है all cases on one day. You maintain the roster 3 weeks, 4 weeks आप आगे पीछे करिएगा. Not necessarily 3 weeks, but we have given you 3 weeks
Lordship.
liberty. You do it. Yes.
18-9. Item 25.
May
it please, your lordship.
Yes.
My lord, this matter, the notice inviting e-bits was issued way back on 29/11/2023. My lord, tender bid committee carried out the evaluation on 13/2/2024. Thereafter, my lord, there was some complaint, my lord, to the district collector in respect of the eligibility of the some of the bidders. Now, that evaluation was again re-scrutinized on 22/2/2024.
Just a minute. The technical bids were
Issued, I mean,
you were
notice.
one of the participants in the tender. You were
Yes.
the bidders.
I was also one of the bidders.
How many bidders were there?
Total.
Anyway, if that is not relevant, you can
It's
avoid.
not very relevant.
That's
my lord.
So you were found to be technically responsive.
Responsive, then ultimately, my lord, the financial bid one, I mean, it was open and I was the highest bidder. And my lord, it was given to me, I have paid rupees 31 lakhs and odd for that. After this, this was challenged. I mean, the re-scrutiny dated 22/2/2024. It was challenged.
This was after opening of the financial bid.
Yes, my lord. Yes.
Then?
It was ultimately, my lord, we have paid the entire amount. And then it was challenged before this honorable court. The learned single judge said that the re-scrutiny was bad in law. And ultimately, although it is not the case of the writ petitioner, even our bid is also, my lord, interfered with. Although it is not their case in the writ petition.
Mr. Datta.
Beg your pardon.
In few minutes, notice this. Who appears for the answering respondents?
Lordship, I am for respondent number 1.
No, respondent number 1 would not be relevant. We want, who are they? The parties? The writ petitioners?
Yes, the government excise department is also there.
Oh, that is true, others. Their response numbers?
They are, my lord, 1 to 4.
So 1 is your appearing. What do you have to say?
Lordship,
No, 1 to 4. Kaise hoga? 1.
Sorry, my lord. This is not 2, 3 and 4. Number 1, Mr.
We are not, we are asking for private bidders.
Private,
bidder, I am-
There are 5, Rajdeep Rajkoa.
then this respond number 1, Shogatam Parjwal.
See, you don't, your memo of parties is absolutely confusing.
My lord, if your lordship see the writ appeal.
Have you made them forget about writ appeal? Have you made them parties?
No,
Those
these
writ
are-
petitioners whose scrutiny was found to be bad.
Withdrawn, no? No, the 3 of them have withdrawn, my lord. They are not in the fray. Only this person is in the contesting party.
Which person?
The other, my lord, the writ
Who is that
petition.
person who is in the fray?
We are concerned in WPC 1385.
So who is that person?
This is Swagatam, Mr. Sharma is appearing on behalf of him.
Mr. Swagat
Swagatam, respond number 1.
Borjo. Yes, and you appear for him.
He is
You have to
appearing.
say, you're ready?
Yes.
Chaliye, bahas kariye.
The lordship has seen that.
Yes.
Are you ready?
Yes, sir.
Yes.
Government.
No. My lord, yes.
Excise pending counsel will be required.
I think they will have a say.
Have you informed them?
They have said in our favor, ma'am. In their, in the writ code by filing an affidavit.
We'll have to see, no? Main argument has to be advanced by him. You have to defend this. You have to defend this judgment.
Oh, Lord.
No.
You have to defend this.
Yes, Lordship. Okay.
Ask the excise department standing counsel to be here, Mr. Datta.
Yes.
Just send him a word. He shall be here tomorrow. We'll pass it over.
All
Tomorrow
right.
hearing, we'll hear it.
Mal.
Ask him to be here.
Mal, I'll just tell them.
Tomorrow, many cases. 21st.
21st, all right.
Let this matter come up for consideration on Sunday.
Yes.